3, 2, 1.
Justice of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business due before this court will draw near, give their attendance, and they shall be heard.
Very good. The first case on for argument today is case 273, People versus Malloy.
Good morning.
Mr. Pisco, good morning. Can you hear us?
I can, judges.
We can hear you clearly. Your opponent has submitted, I believe, and so if you're ready to argue, please proceed.
Thank you, Judge. I'm going to keep this short, Your Honors. I think that it's fairly straightforward. There simply is just not a violation of substantive due process, either as applied or facially, nor is there a violation of the Privilege and Immunities Clause of the Constitution. One thing I just think it's important to point out for the court is that the defendant here is challenging just the designation of sexually violent offender, not the actual registration under SORA, which is important for the reasons I'll get into shortly. But as the court's aware, the Substantive Due Process Clause protects against arbitrary and wrongful government conduct, regardless of the procedural safeguards. However, courts have already decided that because there's no fundamental right to be free from the stigma of being labeled a sex offender, courts evaluate this under the rational basis standard of review. Here, there is a rational basis for the defendant appellant's designation. He was convicted of a registrable sexual felony outside of the state of New York, and New York has an interest in protecting the public at large from sex offenders.
Mr. Pisco, could I stop you there?
Yes, Your Honor.
What would you say the rational basis? Would you agree, first of all, that the defendant was convicted in Kansas of what would be a non-violent sex offense in New York? Do you agree with that?
Judge, yes, I would agree with that.
All right. So then the question for rational basis, is it not, what's the rational basis for designating someone to be a sexually violent offender based on the conviction of a non-violent sexual offense? That's really the question, right?
Yes, Your Honor.
So what is the rational basis for that?
Judge, I think to determine that, we have to look at what the implications are for that designation. And I think the main import here is that that designation requires, depending on the level, longer registration periods. And for cases where the conviction is outside of the state of New York, I do think that New York has a rational basis in requiring a longer registration, because I can attest to this personally. A lot of times when convictions come from out of state, we're missing, we being the district attorney's offices, are missing some information. We get the court file from the out-of-state jurisdiction, but there are some pieces of information that may be missing. So this is a way to ensure that out-of-state convictions, again, that are registrable sexual felonies outside of the state of New York, have a longer period of time registering in New York.
Right. So it sounds like what the rationale is that because you may have difficulty getting records, you're going to assume that everyone is violent, even though their convictions are non-violent. Because we have trouble accessing records. That seems to be the justification offered.
That's not solely it, Judge. I think that's one that I can personally speak to. I do think generally, again, if there is a registrable sexual felony offense outside of the state of New York has an interest in notifying its citizens of that conviction. And for, again, cases where it's out of state, it does also simplify the process for the court. Again, part of the reason why the law was amended back in 2001 was to have a clear identifiable procedure for the registration of sexual felonies outside of the state of New York.
Anything further, counsel?
Judge, I apologize. I was unaware that my opposing counsel had submitted. I'm not going to take up any more time of the court. If the court or any justices have any questions, I'm happy to respond to them.
Just have a question on the facial issue, because it's so different to me. Would you explain that for me? Because I'm not following.
I think, Your Honor, that the facial challenge, again, I'm not viewing this. This is not a case where it's as applied like the recent decision in Brown. I think facially that there is no violation of either substantive due process or the privilege. Well, substantive due process for the reasons set forth in the brief. I believe that there is a rational basis, as explained a few minutes ago, as well as further elucidated in my responding brief. I don't see how the designation alone, and remember, that was the point that I made early on. The defendant's not challenging the actual registration, just the designation, and the only impact that has is the length of time that the defendant has to register. So I don't see, without challenging both the registration and the designation, I don't see how a facial challenge is applicable.
Well, that's a big difference for a defendant such as this. And in the next case where you're talking about lifetime registration as a sexually violent offender. Otherwise, it's 20 years. These two have been registered sex offenders for quite a while already. So we're talking about the rest of their lives or them coming off pretty soon. That's what's at stake here for them.
And Judge, I don't want to trivialize, again, the fact that the registration would be a lifetime. My position, the people's position, is simply that that's not a violation of substantive due process or the Privilege and Immunities Clause.
Okay. Thank you, counsel.
Thank you, Your Honors.
Next case on for argument, case 274, People versus Zelfro.
Your Honors, if it's agreeable to the court, again, I'm happy to respond to questions, but since my opposing counsel has submitted, I'm happy to allow the court to move on.
No questions. Thank you, counsel.
Thank you.
Case 275, People versus Woods. Very good. Both counsel are here. Counsel Goldfarb, can you hear us?
Yes, I can. Can you hear me?
And we can hear you loud and clear. Counsel Dana?
Yes, Your Honor, I can hear you.
Very good. Let's proceed, counsel.
Okay. Good morning, Your Honors, and may it please the court, Sarah Goldfarb on behalf of Mr. Clifford Woods. This is precisely the type of case for which the merger doctrine was developed. Mr. Woods' actions towards the complainant amount to forcible touching and stalking. Yet the prosecution charged kidnapping, presumably to expose him to that higher sentence. Here, any kidnapping that occurred should merge with the other crimes charged because any restraint of the complainant was so much the part of another substantive crime that substantive crime could not have been committed without those acts.
Ms.
Here-
Goldfarb,
Yes.
don't we have to assume for your argument that the jury disregarded the victim's testimony about him grabbing her, I think, on the buttocks about maybe 2 minutes before she went under the bridge, then came back, and then when he ultimately put his arms around her, that was a separate event. Don't we have to assume that the jury disregarded that?
Disregard.
Disregarded that he actually grabbed her buttocks 2 minutes before he wrapped his arms around her, because
No,
otherwise it's a separate event.
I don't think so, because I think it was a continuation of the forcible touching wasn't limited in the indictment to just the touching of her buttocks. So I think the entire event, the forcible touching and the stalking together, both of them were ongoing throughout this few-minute situation with the complainant. And so I don't think you need to disregard that touching of the buttocks had occurred. I think you can take that and then see that this was just the natural progression of both the forcible touching and the stalking. So complainant had testified that she was walking down South Clinton Street when she was approached by Mr. Woods, and he started, he grabbed her hand, asked for her name, and started following her down the street. And then, she had asked for him to leave her alone. He did not do so. He kept following her, as you said.
Counsel, we know the facts of the case, right? And the video, interestingly, we have a couple of views of the video here of what transpires.
Correct.
And so instead of reciting the facts, why don't you get right to your argument?
Okay, my argument then would just be that this conduct is similar to the circumstances that were considered in Cassidy, the Court of Appeals case that considered 3 different fact patterns, all of which the Court of Appeals found that there was no independent abduction. And our argument is that the facts of this case are similar to the facts.
There seems to be some testimony from the victim that once and I'm not sure this is has meaning or not, and I want to ask you what you think. Once the defendant came from behind her and grabbed her, it was kind of like a sudden move. He was following behind her down the street at a close distance, but then there was a lunge. To my view, there was a lunge and a grab, like a bear hug grab from behind. Does it matter? Do we need testimony from that point forward that shows him trying to move the victim somewhere to get to kidnapping? Or and if so, is that testimony present?
So first I'll talk about what testimony we do have. We have testimony that they moved about 1 or 2 steps. There wasn't any movement anywhere further. And so I think that is integral, because if he were intending to move her to, a nearby apartment or something like that, as the prosecutor was suggesting, I think there would be more testimony about them going further. It seems like these were just steps that were taken because he was grabbing her, trying to perhaps get a good hold of her.
It didn't seem from my viewing that there was a difficulty with him, like once he grabbed onto her. The size difference is pretty significant. And had this defendant if he wanted to move her to another location, he could have moved her. And frankly, watching this video, watching people walking by and cars driving by, and you can't hear it on the video, of course, but the testimony is that she's screaming out, but for one car stopping, nobody's coming to her aid. He could have picked her up and started moving her across the street if that's where he wanted to take her, somewhere else. That didn't happen, right?
Right, that's correct, Your Honor. As you said, he could have. Had he wanted to take her somewhere, he could have. And because he didn't do so here, it's clear that he wasn't intending to commit any kidnapping. His intent was just to continue the stalking, continue this forcible touching, who knows, what else. But it's clear that he could have, grabbed her, kidnapped her, taken her wherever had he wanted to, and he did not do so.
Could I ask you, with respect to your brief, as I read your contentions, your argument is that the kidnapping charge should be dismissed because of the merger doctrine. There's a continuous touching going on, and it's part and parcel.
Correct.
You are not arguing, I don't believe, that the evidence was insufficient to establish kidnapping, the elements. You are not arguing that the verdict on kidnapping is against the weight of the evidence. Do I have that right?
That is correct, Your Honor.
So, but for this merger doctrine, if the touching had clearly, if the DA and the indictments specified the forcible touching was the grabbing of the buttocks earlier, 2 minutes before, there would be no merger, at least with respect to that. There would be no dismissal of the kidnapping, at least on that ground.
If the indictment specifically limited the forcible touching, correct. That is correct, Your Honor.
Because it does seem kind of light on evidence that he actually kidnapped her. But So, but you're not arguing that.
Right. I think it was my understanding that kidnapping was just the holding and preventing her from moving further. So that's not something that we're arguing. We're arguing that
Well, that's enough in your view, just holding her, that's enough for not letting her go further, that's enough for kidnapping?
I could submit something further if you would like.
Well,
I
no, I mean, I'm not sure you can raise new arguments. I'm just trying to clarify what you're actually
Right.
arguing, but thank you.
Yeah, correct. And this here, we're just arguing that this kidnapping charge should merge with the other.
Very, very briefly, Ms. Goldfarb, on the case that you cited, Cassidy, and the other two cases that it was part of, it was all one decision. In those cases, it seemed to me the difference that we had with respect to the merger doctrine is that the grabbing, the holding, the moving, and we can talk about how much the defendant here was moved, although I don't know if it matters too much based on the argument you're making. But all of that happened in Cassidy and the other cases before the other act. The grabbing happened first, took them someplace, and then something else happened secondary to that. Here it seems the difference that we have, and I haven't seen any other cases that are like this one, the other acts occur before the grabbing and moving. The stalking and the forcible touching, perhaps with the grab of the buttocks, happens before. Does that make a difference in your mind?
I don't think it makes a difference because here, the stalking and the forcible touching, that was all happening. All of these were continuing actions that happened close in time with one another. So I don't think it should matter that this case is different than those in Cassidy because the kidnapping had happened earlier than the other crimes.
The reason I ask again, I don't want to belabor the point. Had he never grabbed her, had he, at the moment he's about to grab her, had he thought twice and backed away at that point, could he still be convicted of forcible touching and the stalking based on the events that happened up to that point?
Yes, he could. He could, but that forcible touching and that stalking continued when he grabbed her, or at least the forcible touching did, because he was grabbing her right around the chest area. So that continued.
Does it matter that the DA in the summation tied the forcible touching to the grabbing of the buttocks? I know the indictment was not specific, but in the summation, as I recall, it was tied to the first touching, was it not?
I believe you are correct, Your Honor, but I don't think that matters because it wasn't specified differently in the indictment. And also in the jury instructions repeated the same language, not limiting the forcible touching to just the touching of her butt.
Anything further, counsel?
No, if there are no further questions, then I rest on my brief for all other points.
Thank you. Counsel, proceed. Oh, you're on mute, counsel?
Thank you. Elizabeth Dannon for the people. Yes, Your Honor, thank you. We would just reiterate that the forcible touching was definitely tied to the grabbing of the buttocks. That is an intimate part. He gave her a bear hug, which does not suggest that that was an intimate part of her body. We also would just
your breast an intimate part of your body if you're a woman?
There's no allegation that he was touching her breasts. He was just kind of grabbing her around the chest area. It did not appear that there was any allegation that he was groping her while he was grabbing her in any way, Your Honor.
Anything further, counsel?
No, Your Honor, we would rest. Thank you.
Thank you. Case 276, People versus Rosania. Mr. Punch, can you hear us?
Yes, Your Honor.
And we can hear you. Counsel Culprit, can you hear us?
Thank you, Judge.
Very good. We can hear you. Please proceed, counsel.
Your Honor, this case, we're arguing that it was premature to dismiss for constitutional violation of speedy trial. The most important factor here is the reason for the delay. That's because our court system couldn't secure a proper Ukrainian interpreter for the defendant. It hasn't been alleged that the people caused this delay. Under the circumstances, and if you look at the remaining Taranovic factors, everything militates against dismissal. And it was simply premature in this case. Additional steps had to be taken when it was determined that that just simply ordering a Ukrainian interpreter would be insufficient.
So what would happen if no interpreter is obtained and a year went by already, right? So a year and a month. So it's not your fault. The DA is not responsible for that. But say we get into year 2, 3, and 4, still no interpreter. You don't think that would be a problem on
Well,
constitutional?
no,
speed?
Your Honor, that would absolutely be a problem. I stated in my brief that, of course, there is some point at which it would have to be dismissed, even if it was not the people's fault. Here we have 214 days from indictment. That's when the delay started that was being caused by this interpreter. It's my position that that's not an extreme delay. When it's not the people's fault, case law says that it has to be an extreme delay, and 214 days is not.
Counselor, the argument here isn't that it's the people's fault. It's the delay itself that violated the defendant's constitutional rights. And in this case, the first 2 appearances, there was indeed a Ukrainian interpreter in the town of Clarence Court, wasn't there?
That's correct.
And so we went 7 appearances without an interpreter, a competent interpreter.
Your Honor, I'm not sure if it was 7 appearances, but there was multiple appearances. I know some were called off record because an interpreter wasn't there. But yes, each of those, if it was 7, each of those, all that the court did, or all that was stated that the court did, was order an interpreter. My position, we can't just dismiss a case because the defendant speaks a different language. Additional steps have to be taken. Apparently that interpreter did not come. She refused to make downtown daytime appearances. It would suggest, I would suggest that it could be, you could go out to Clarence and hold court if you had to, but something has to be done.
But counsel, interestingly, it's not your responsibility to arrange for the interpreter. I think that's pretty clear. Whose responsibility is it to arrange for the interpreter, if not the court systems?
It is the court systems.
Right? And so to the extent that the court system falls down on a case like this, not your office, but the court system, are you saying that there's a certain number of months or years that we have to get to before we can say that the defendant's been prejudiced to the point where it's a constitutional violation?
Well, Your Honor, overall, yes, I am saying that. There's no, with the constitutional speedy trial issues, there's no, I can't pin down a number of months.
Right.
Take them all in consideration. There's no actual prejudice. She never served any pretrial jail time. Under these circumstances, the delay should not be considered extreme, especially in comparison to other cases in which the courts have found, 5 years, 6 years, 8 years have been extreme, and I would agree with that.
Counsel, in your estimation, would the amount of time vary depending upon the complexity of the case? In other words, if you have a simpler case, is it a shorter period of time? If you have a very complex case, there's additional time provided for both the prosecutor's office and the court system?
In general, yes, I would agree with that, Your Honor. But in this case, none of the delay. The idea is that if it's a very complicated case, the DA's office would be given naturally more time to prepare for it. We weren't seeking delay on those grounds, and I don't think the delay was caused by the complexity of the actual case. It was only caused by our lack of the ability to get a Ukrainian interpreter. So I don't know if that single factor plays in this situation.
Thank you. Anything further?
No, Your Honor. Thank you.
Thank you, Counsel. Counsel Colpit?
Good morning. If I may please the court, Jessica Colpit on behalf of the respondent, Oksana, and I'm going to just say B because I can never properly pronounce her name, so I apologize.
Yeah.
Your Honors, in this case, as the court has already identified in some of the questioning by your justices, this was an appropriate remedy for the situation that was before us. First, I'd like to address Judge Del Conte. It was 7 separate appearances: November 14th, 2022, November 29th, 2022, December 6th, 2022, December 20th, 2022, January 25th, 2023, March 30th, 2023. And then finally on June 6th, I filed for the dismissal. One of the things that the people are failing to identify is the case law in looking at these types of cases, which are rare. I would imagine that this court doesn't regularly see appeals or hear cases on this. In the 15 years I'm practicing, this is the first time I've ever filed anything on a DWI in this circumstance. We could not even commence the court proceeding. There is inherent constitutional delay when we force people to wait. And if we are going to force these people to wait based on solely the inability of the court to procure an interpreter, and I think here that the people are making some kind of assumption it has to be related to the prosecution. I believe Judge Barnese in his decision went through thorough steps to say this is not part of the prosecution's fault.
Ms. Culpet, let's say that I agree with you that the second factor, the reason for the delay, militates in favor of dismissal. There are 4 other factors. The first one being how long was the delay? In researching this issue, the longest delay where a case has been dismissed by our court or the Court of Appeals that I could see, where somebody was not in custody, because your client was not in custody, that's a big factor. There's no case even close to 408 days, and that's assuming we're calling, this is a year and a month and a week or so. The days where the delay on cases that have been dismissed for constitutional speedy, right there, we're talking years, 6 years, 10 years, 12 years, 18 years. This is the shortest delay I've seen where a case has ever been dismissed. So that's the first factor. And then we have prejudice, the last factor. I think you would acknowledge your client showed no prejudice. In other words, she didn't say, well, some of my witnesses are no longer available or anything like that. I think there's this concept, there's presumed prejudice anytime there's delay. But if we were to presume prejudice on a delay of this duration, really short compared to other constitutional, then there would be prejudice in every single case. So that factor, the first and fifth factor, if we go your way, would work for the defendant in every single case, it would seem. And you agree that the one factor, your client was not in custody, that goes in favor of the people. So if you could speak to the extent of the delay and the prejudice, those are the 2 that I have the most problem with.
Well, with respect to the extent of the delay and the other circumstances that Your Honor is indicating that continue many, many years, all those proceedings had commenced. And one of the things that's not addressed by the people is that the crux of this argument, my argument, and it was in my motion to dismiss, is that she never should have been arrested and the probable cause didn't exist based on the language barrier from the very commencement. And I think the people in the record even submitted the body camera up to Your Honors to see that that was the issue. So in this case, when I think the court considered the extent of the delay is we couldn't even get through arraignment properly. And on one of those occasions, Your Honor, and when we talk about the prejudice, and I understand that this may be non-traditional prejudice, but I finally agreed on the record because of the anxiety, which the lower court can see. My client couldn't eat or sleep for 2 days before she appeared. She came into the courtroom shaking, crying. It's somebody without a criminal history. So I understand that we're talking about this extended delay.
She blew a 1-3 driving a motor vehicle with kids in the car.
That is the allegation, Your Honor.
Yeah. But it sounds like you're saying the prejudice is, well, she might win on probable cause. So that's prejudice. That
is not what I'm saying, Your Honor. I'm saying the prejudice to the client and having an undue delay in a proceeding that can't even commence was something that was visible in the courtroom. And I'm demonstrating that prejudice through the final exasperation and the agreement that I'll say, hey, let her friend do this. Because the mental state, although she wasn't in custody, that the duration, that constitutional delay that she was under, waiting to undergo these proceedings so I could properly challenge them, occurred repeatedly. And that's something the lower court could see, right? That's something that the record doesn't show, but I could demonstrate in why on earth would a lawyer just agree to allow this non-traditional proceeding to make it force on? Well, let me tell you why I did, because she couldn't mentally withstand the continued delay. So with respect to the duration, I'm answering Your Honor's question and saying, in this case, we couldn't even start it. And it was demonstrated in my papers that if we can't even get it here to say not guilty, how is she going to understand and help with motion papers? How are we going to get through a hearing where she has to have an interpreter and each and every subsequent proceeding thereafter? So the extent of the delay was considered by the court in this unusual case, number one. Number two, the prejudice in any case is inherent, and I understand that always goes to a defense, but in this case where we couldn't even commence it with what the court could physically see, right? And unfortunately, this panel is at slight detriment, so I can only demonstrate it through my exhaustion and agreement to do something I wouldn't usually do, right? To help her move this forward. And that's how I would address that, Your Honor. And I'm happy to, Judge Lindley, I'm happy to take additional questions if I failed to.
No, you did fine. Thank you.
Anything further, counsel?
Your Honor, this isn't, and I would just say in closing, this isn't a case where I'm suggesting this court should demonstrate a new rule, that this is the right number. And as my opponent in the district attorney's office has pointed out, they can't tell you what the appropriate number is. And that's why we have these factors. That's why we have to consider these cases on a case-by-case basis, which is exactly what Judge Barnese did, and I believe you should uphold his order in this case, in this very limited facts and circumstances. I'm not suggesting this panel should say, hey, when we hit the year and 1 month mark, 7 appearances, let it go. I'm saying in this case, with these factors, on this situation, on this arrest only, this remedy was appropriate and should be upheld. Thank you.
Thank you, counsel. Case 277, People versus Dublino. Justice Ogden is recused. Okay, we have both counsel present.
Yes, Your Honor.
Can you hear us?
Yes, Your Honor.
Counsel Van Leuven, can you hear us?
Yes, Your Honor.
And we can hear you. Please proceed, counsel.
May it please the court, Lyle Hoydu for defendant Mark Dublino. I submitted a brief raising 5 points on behalf of my client. Unless the court directs me otherwise, I will focus on point 1. And if there's any time, possibly point 2. The defendant here had a fundamental right to self-representation, and we're arguing that that was improperly denied by the court. When the defendant made his application in front of the first judge in the case, that judge actually relieved defense counsel of his responsibilities, appointed that same attorney as standby counsel, and unfortunately, for Mr. Dublino, that judge did not stay on the case. When the second judge came onto the case, he conducted his own independent inquiry. He did not honor the prior holding of the court, and that judge denied relief. We're arguing that that was improper. We have in this case a remarkable record because there are extensive exchanges between Mr. Dublino and the court, talking about his education, his understanding of the law, whether he understands the charges against him, gets into amazing detail in terms of how to pick a jury and how to present evidence. And all of that supports the defendant's application for relief to have been granted. I would just note the record is there. There's 15 pro se motions that he filed. He raised important issues. He did a remarkable job in prison without the benefit of office and legal resources. He properly served the parties and submitted the appropriate motions. There's when you look at the second judge's exchange with the defendant, and I actually recited that in my brief so the court would have it. It's very clear that he understood the proceedings. He understood the difference between peremptory and challenges for cause. He even knew how many peremptory challenges that he was entitled to. So it's quite amazing.
Counsel, if I could interrupt you just for a second.
Yes.
Just assume for the sake of the argument that I agree with you that the court's analysis initially was in error, right? And he had a right to self-representation if he wished it. There was a proceeding, according to the record, on March 23rd, 2021, where there was a conversation between the court and him about whether or not he wanted to continue with his request to self-represent. And ultimately, he seemed satisfied with counsel. And my question to you is, why should we not find this to be an abandonment of his request to proceed pro se?
I think when you look at the record, Judge, and it is muddled in that regard, and a lot of that is not the fault of the defendant. It's just how things were placed on the record. He had a fundamental right to have counsel appointed. Once the judge denies that, I mean, his remedy really is to file an appeal from the judge's decision. He's not required to reaffirm his position throughout the trial. It's no different than if the judge made a ruling against him on an evidentiary matter. He doesn't have to reaffirm that he still wanted that motion to go forward. So I would argue that once he made his application, once the court rendered its decision, that was the court's decision. There's nothing to revisit at that point.
What if the defendant says, no, I've changed my mind. I'm getting along real well with my attorney. I'm good here. I don't want to self-represent. That would be fine, right? You can abandon.
After the court grants relief, he could.
Let's say we have the same fact pattern here. The defendant says, I want to self-represent. The court says, no, you don't understand Batson. You don't understand peremptories, whatever. Then before the trial, there's some more back and forth. And the defendant says, you know, I'm all set here. I like my lawyer. We're communicating well. I just want to consult with my lawyer. I'm fine not self-representing. That's okay, right? For the trial judge, even though the trial judge made a improper ruling previously, we wouldn't reverse on that situation, would we?
Okay, so Judge, in your scenario, you're saying that the judge denied his application.
Yeah, and then the defendant changes his mind. He gets along better with his lawyer before trial, as here. Because look, here the judge seemed to ask a very direct question. It says, my question is very direct. Are you now satisfied with counsel? You no longer wish to represent yourself?
And my argument would be, excuse me.
And then your client said, yeah, he was satisfied with counsel and only wanted to ensure sufficient time for consultation. So it sounds like he abandoned his request. That was a legitimate request and should have been granted previously, but before the trial, he seemed to have more confidence in his counsel.
It'd be the same argument if the judge had ruled against him on a search and seizure where he had filed a motion to have the search or the items that were recovered thrown out, and then later on the judge is asking him if he's basically, are you reaffirming your position on the motion that you previously filed? That's the distinction I draw. Is once the judge denies him his lawful right to proceed, then to later on ask him, you know, you thought that was a strike and I called it a ball, or vice versa. Do you think now as you look back, maybe I made the right call? That's a different issue. So that's where I'm hung up, judges, because once he's denied that right, how he's being, I guess, asked to reaffirm that he's still making that challenge, and that's not required under the law.
Okay.
Very good. Thank you, counsel. Anything further?
Thank you.
Counsel, proceed.
Good morning, Your Honor. Mindy Van Leeuwen for the people. Your Honor, I would state, first of all, that the defendant doesn't make a whole lot of equivocal requests to proceed pro se. If they are equivocal, then he isn't demonstrating that he understands the proceedings. And even if he has the first two, then he's not demonstrating that he wouldn't prevent the orderly exposition of the issues. So there's a multitude of issues that goes along with that. What I would state was there's been some confusion with regards to the time Judge Mahalski does say, yes, defendant, you can go ahead and proceed pro se. He's in the middle of a inquiry with regards to proceeding pro se. Not even 3 pages later, the Judge Mahalski states, and I had it up here, that he is leaving Mr. Arricchio of his duties, and he's going to reassign counsel. Because in the midst of that searching inquiry, the defendant says, oh no, I don't want Arricchio as even standby counsel. You know, I just want to do this by myself kind of thing. So first of all, even though that one was equivocal, yes, the Judge Mahalski kind of said, you can proceed pro se. He said, I'm relieving Mr. Arricchio as your counsel. I'll appoint him as standby. Not even 2 pages later in the testimony, in the same instance, he said, okay, I'm just relieving Mr. Arricchio. So he didn't actually ever allow him to proceed pro se to begin with. So I think there's been some confusion about that I wanted to highlight to make sure that that was less confusing. The other thing I'll say is there was multiple abandonments. Usually the defendant would have some digressive speech about something, and he does show some retention of what the law is, but other times he'll talk about qualified immunity for what seems like several pages of this 1,500-page transcript. So just because he understands some things doesn't mean he doesn't understand other things. So the people—
Look, if that's a legitimate basis to deprive somebody of their right to represent themselves because they can't answer certain questions on the law, then nobody would be allowed to go pro se. I mean, you could ask me a lot of those questions, I wouldn't know.
Absolutely, Your Honor. But that's why we highlighted the fact that he had to have all 3 of these things. He had to have an unequivocal request. Some of them were equivocal. Some of them were saying, well, no, I just don't want X, Y, and Z, versus he wants to proceed pro se. He'll say, no, I just don't want Mr. Arricchio, or no, I just don't want this going on, or I'm mad about something that's happening in the jail. So first of all, he doesn't have all 3 things at one time. And the biggest thing is most of these times he's using this as a dilatory tactic. He is preventing the fair exposition of the issues. He had multiple trial dates scheduled, and every time a trial date's scheduled, he's unhappy with something, and then he says he wants to proceed pro se, and then he retracts his statement. So, Your Honor, ultimately, we would say that he didn't have all 3 of the things that are required at one time, and we would also contend that he did abandon his request, and therefore his rights were not violated with regards to that issue. Unless you're—
Thank you, Counsel. Yep. You had nothing further, right? You had concluded?
Yes, Your Honor.
All right, sorry. Thank you, Counsel.
Thank you.
Case 279, Torres versus Rochelle. Okay, Counsel Cons, can you hear us?
I can.
Very good. Counsel Maris, can you hear us?
Yes, I can, Your Honor.
Very good. Thank you very much. Please proceed.
Given the fact that the appellant has submitted, I won't take up much of your time. I would just like to reiterate that the family court is in the best interest to do credibility determinations, which they did in this case. And the basis is supported in the record. And unless the court has any questions, I'll rest on our brief.
Very good. Thank you. Counsel Maris?
Good morning, Your Honors. May it please the court, Susan Maris, attorney for the child, who is now 10 years old in 4th grade. May I update the court on the status of my client?
Please do.
She seems to be very happy, well adjusted with her family. She's doing well in school. She's involved in extracurriculars. And one thing she wanted me to tell the court was she would like for her mother to stop talking to her about the custody. She's very upset that her mother continues to talk to her about the custody. And she's also told her grandfather, the mother's mother, and she's upset by that. But other than that, she seems to be doing very well. And unless there's any questions, I'll rest on my brief.
No questions, Counsel. Thank you.
Thank you.
Case 280 in the matter of Radcliffe M. Okay, very good. We're waiting on, nobody. All right, counsel, first of all, can all counsel hear the court?
Yes, Your Honor.
Yes? Ms. Whiteside? You're on mute. Yep.
Thank you. Yes, I can.
Yes, very good. And Counsel Forst?
Oh, yes, I can hear everyone just fine.
Very
Thank
good.
you.
And we can hear you. So counsel, please proceed.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. Guy Talley on behalf of appellant in this matter. A finding of permanent neglect is a serious matter, and the termination of parental rights is a drastic measure. For these reasons, the legislature has placed a paramount and pervasive obligation on the part of petitioner, once it has obtained custody of children, to engage in repeated, affirmative, and meaningful efforts to reunite the parents with the children. The Court of Appeals has held in the matter of Sheila G. that before you can even assess whether a parent has permanently neglected their children, the agency must first establish that it has engaged in these efforts. And in the matter of Jamie M., the Court of Appeals has held that finding of non-cooperation also presupposes that the agency has engaged in these efforts, as does the statute relating to non-cooperation of incarcerated parents. In this case, we have kind of a gross derogation of the agency's responsibility. The first instance, they didn't comply with very basic statutory obligations, and I think that they were very far from engaging in repeated, meaningful, and affirmative efforts. As alluded to, there's two grounds upon which a parent can be found to have permanently neglected their children. One is a failure to maintain contact, and the other is a failure to plan for their future, for their reunification. First, with respect to failure to maintain contact, it's undisputed that the agency did absolutely nothing. It did not, as it was required to do under the statute, it was supposed to reach out to the facility, arrange visits with the children, and it's undisputed that it did none of that. And I think as I read petitioner's responding brief, to me, they seem to have abandoned that as a ground for finding a permanent neglect in this instance. So I will move on to the failure to plan. In this instance, again, there is a lack of agency efforts and requirements that it was supposed to engage in. I think the primary ground here was they faulted my client for not providing a viable resource to care for the children while he was in prison. The first instance is when the first time he was asked, I think within 2 weeks, he provided the name of his sister. And the agency supposedly reached out to her. That's kind of disputed in the record on that, but a family court found that they had made attempts to reach out to her. But the problem is they had never done anything. They had never told my client, first of all, they never sent him the pamphlet advising him of his rights and obligations. Second of all, none of the letters they ever sent him advised him of the consequences of not finding a viable resource. And they never really even asked him for another name. They said, if you know of anyone else, just let us know. And
counsel,
sure.
It looks to me like the record did reflect it, that the father sent the maternal grandmother, Robin Rosario, with whom he was close, it seems, 118 emails while he was incarcerated, but 0 to the caseworker, even though the caseworker's email address was there in response to all of these letters. So that there really wasn't a lot of an effort on the father's benefit, I guess, or on his own benefit when he was incarcerated. The question I have, I guess, pertains to the statute, however, and that is that it seems that under the social services law, that diligent efforts are not required if the father fails on more than one occasion to cooperate, which strikes me as kind of a severe standard for folks that are incarcerated. Do you agree with it? And if so, are we bound by that?
Well, I think that I think that the standard is that they have to fail on more than one occasion to cooperate with the agency's efforts in assisting the parent to plan for the future of the child, or assisting the parent, to maintain contact. And so I think in this case, the family court kind of misapplied the non-cooperation statute by almost relieving the agency of obligations beyond sending letters that didn't really advise them properly of what they were supposed to advise them of. And so I think that even in non-cooperation, and I think Jamie M has held this, it presupposes that the agency has engaged in efforts already. Now, whether you call those diligent efforts, whether they're reasonable efforts under the circumstances, I mean, it's kind of it's a little bit vague as terms of the level of efforts required, but it's certainly more than what was done here. And to your point about my client reaching out to the mother-in-law, he was interested. He wanted to keep in touch with his kids and what they were doing. And the fact that he didn't send an email to the caseworker, I think, he mentioned, there wasn't a lot of development in the record about prisoners' abilities to email folks. I think you have to get them on a list. They have to be approved. But he kind of alluded to that, saying, well, I didn't know I could email him. He wasn't on the list, and he was worried about disciplinary measures. Three-way calls, I know, are prohibited from representing criminal clients if you conference someone in. So apparently the mother-in-law was certainly on the list, and that was more important to him. But going back to your initial question about the efforts are required before non-cooperation can be found. That's in the statute. That's in a matter of Jamie M. It's a matter of common sense. You have to not cooperate with something. And I think the agency efforts here did not reach that level of efforts to fault him for non-cooperation for all the reasons outlined in my brief.
Counsel, do you want to address your point 2 on the suspended judgment?
Sure, Your Honor.
Your client was on the verge of being released. He's not in custody currently, correct? He was released.
That's correct, Your Honor.
Yeah. Go ahead.
I'm sorry.
No, I'd like you to address your point 2.
Okay. So yes. So after the finding of permanent neglect, there was a dispositional hearing held. My client was released 60 days prior to that dispositional hearing. And, he requested more time. He wasn't saying, I'm ready to take the kids back right now, but he had hit the ground running. He had gotten a job. He had taken significant efforts towards, trying to get these children returned to him. And again, he did it without any assistance from petitioner. There were no efforts done while he was in prison to set him up with services. That's also a statutory requirement. They're supposed to facilitate, services while he was in prison. But it wasn't until I think the Friday before the hearing that the caseworker first gave him referrals for, mental health or services and drug abuse services, and he was willing to do those. He had done some. And I think that the day of the hearing is when he gave him the parenting referral. So, and my client had no objection to doing that.
So the argument was on his behalf that a suspended judgment might be appropriate in this case. He's released. He's endeavoring to work hard to get this, whatever he can get done as quickly as possible. And once he was out, he was more free to do those things and engage in those services. Does the fact that the children, I understand from the record, the children have some type of learning deficit, is that right?
I think one of them was on an IEP, Your Honor, and I'm not sure what the issues were with that. But yeah, I do believe the younger child has an individual education program.
So that could factor in on your point 1 with respect to his ability to reach out to them and to communicate with them, and whether or not he thought that was a good idea or not a good idea. Is that part of what you're arguing here?
Absolutely, Your Honor. I mean, there's certainly considerations for a father with children of that young age, that are involved in visitation and talking with them while you're incarcerated in a situation like that. I think petitioner even alluded to some of them in their brief. There's certainly considerations in that respect, and they might not understand what's going on and what's happening. So yeah, I would agree with Your Honor with that.
All right, thank you, counsel.
Thank you, Your Honors.
Counsel, proceed.
Yes, Your Honor, Mary Whiteside for the Department of Human Services. In this case, the appellant, it was not one instance where he didn't respond. It was almost the entirety of the case that he didn't respond. He didn't respond to SPR invitations where he could have called in. He didn't respond to the caseworker where he was encouraged to reach out, to plan, to discuss alternative placements to foster care. My client did speak to him on the phone, did initiate a phone call in a few months after the children were in foster care. They came in March 2020, and so this is August of 2020. The appellant testified that he was aware that the children were in foster care in March of 2020, that they had been removed by the mother. There's no testimony from the father at either the fact-finding hearing or at the dispositional hearing that he ever was a primary caregiver, that they ever lived with him. He didn't testify as to the extent of their relationship, the type of caregiving that he gave. Not once did he mention any of this. He didn't reach out to offer phone calls in October of 2021. And my client did provide him with information via letter because he wasn't able to speak with him about how he could reach out and set up phone conversations with his children. And he didn't, initiate that. So, this isn't an instance where, it was one situation that the court said, oh, one situation, okay, we're going to find no diligent efforts. My client was repeatedly sending letters and he's incarcerated. So,
counsel, can I just ask you something? He was incarcerated before the children were removed, correct?
Correct. Yes.
And then COVID intervened in the midst of all of that, correct?
Correct. It did.
So what efforts did the agency make once he got out and he reestablished the relationship with the children? Why didn't the agency do some things to maybe offer him parenting classes and substance abuse counseling earlier?
Well, they had asked him to do a substance abuse evaluation. He had said that he had completed substance abuse while he was incarcerated. And so they were waiting for documentation of that. And they did request that he get a substance abuse evaluation, which at the time of the dispositional hearing, he said he wasn't able to do because of transportation issues. He was taking the bus and he would be unable to do that, even though there are substance abuse evaluations in the evening. So, whether he was truly unable to do that it was for the court's determination. It's in the record that a parenting class hadn't been provided prior to the dispositional hearing or the date of, so that would have been more ideal. The dispositional hearing was set 60 days after he was released. They had set up visits and he was visiting at that point after he was released. So he was visiting once a week with the children. There were no safety issues or anything with those visits, as that was testified in the dispositional hearing. They'd made referrals for housing, for him to find some stable housing. And he hadn't, by the point of the dispositional hearing, he was staying with a friend. He had not provided even the address of where he was staying. There was no ability to check any of that out because he wasn't providing any specific information on that. He had reported that he was working. He had not provided any documentation about that. So while he was answering his phone calls when the caseworker would call him, there wasn't a lot that the agency, other than providing a parenting referral, which would have been ideal, could have done to further check on those things, because it requires, of course, the parent to provide that type of information, and the caseworker checks that out.
Whiteside, the issue in these suspended judgments is always like, what's the harm in giving a parent, especially one who was handicapped while incarcerated, certain things he could not do? What's the harm in giving him another opportunity here? If he doesn't do what's needed, then there's no harm, no foul. Is the harm here that these children have been in foster care for 4 years now? They think they've been adopted, I believe, based on the briefs, and that there's a need for finality for them. Is their need for finality greater than the need to ensure that this man is given full opportunity to try to win his kids back?
Well, at the dispositional hearing, the we're looking at the best interest of the children. That is what is the primary consideration of the court. And in this situation, the appellant did not provide the court with a feasible plan. There was no timeline. There was no set of steps that he was going to take. It was kind of amorphous as to when he was going to be able to obtain housing. He was non-committal that he would get a substance abuse evaluation. He had claimed that he'd had mental health while he was incarcerated. However, the documentation from the prison, while it did substantiate substance abuse, it did not substantiate mental health. So there were still several things that he needed to do, and the court was unsatisfied that he had a feasible plan that would be able to be accomplished in a suspended judgment, which is a short duration. So yes, I believe that the court's consideration was whether or not that he provided a feasible plan that could be justifying a delay. And the court was unsatisfied that he had done that, and felt that it was in the best interest of the children, who had been in care at that point 2 years, at this point 4 years, with the same foster parents, which are a pre-adoptive home, providing all of the children's needs, taking them to mental health appointments when necessary, and that the best interest weighed in favor of the foster parents at that point.
But counsel, I don't see that these children were adopted.
No, they were not adopted. Okay. No, I said they are a pre-adoptive, right. And the attorney for the child can address the children's beliefs at that time, that nothing was conveyed to them by my client, or my understanding by the foster parents, that they had been adopted, and that could be further clarified by the AFC.
Very good. Thank you, counsel.
Thank you.
Counsel Forrest.
Good morning, Your Honors. Kelly Forrest, attorney for the children, Rodcliffe M. and Levon M. First of all, I would like to provide an update to the contents of my brief. Two things. Number one, I do believe that I did have a misstatement of law in there, for which I apologize. I believe I said that the county did not have any responsibility to the appellant until a petition had been filed. That is incorrect. I should have said until the children were in foster care. However, the very first letter to him went out the day after the children were placed. I'd also like to update the court, if I might, about my contact with the children. The county has been in touch with the foster mother, who I believe is a little bit overwhelmed with all of the people who are involved. There's caseworkers, there's another AFC, and she has a number of foster children, actually. And I think that when she was ignoring my calls, she wasn't really understanding what my role was. The county has encouraged her, and she did, in fact, get in touch with me, and I met with my clients about 3 weeks ago. When I met with the boys, they are delightful little boys.
Also, give me the ages again of the boys.
They are now, Rodcliffe is presently 9 and Levon is presently 8. Their birthdays are this summer, both of them. So they'll be 10 and 9 shortly here. They've been in foster care about half their lives, essentially. What they explained to me is that, or what the foster mom explained to me is that about the issue of them being adopted, there are other foster kids in the home who have talked about being adopted. And these kids kind of jumped on board and said, yeah, we're adopted too. And foster mom really didn't think that it was appropriate or necessary to correct them. So when the AFC for permanency planning explained to me that they think they're adopted already, she didn't give me all that background. And so I think that's why there's this miscommunication or misunderstanding that somebody else had told them they were already adopted. I explained to them that their adoption has not been finalized yet, that they're going to go to court. I asked them, what they thought about that. They thought that was a great idea. They've been with these folks for 4 years, and it's really the most stable family that they've known. I think, when I talked to them, they were ambivalent about their father. What's really important for the court to understand is that Rodcliffe, the older boy, did relate to me the story about his father having put his gun into this child's backpack and how he saw him do it. He knew it was there. He knew it was dangerous, and he was scared. I don't really know. It's unclear to me whether that was the weapons charge that our appellant was actually ultimately convicted of. But in any event, that was a traumatic event for the child. I would also remind the court that there were a number of domestic violence issues between the appellant and the children's mother while they were living, at least with her. It's unclear whether he ever lived with them, but those were certainly traumatic also to the children. So he goes to jail in 2019. He's arrested in 2018, goes to jail in 2019. The only thing these children know about their father, and this goes to the relationship that he had with them, which the county was charged then with, encouraging, reinforcing, and making happen, I guess, is that first he's traumatic to them. I'm sure there was some good things about, their relationship early on. But there's this domestic violence, there's this putting the gun in the boy's backpack, and then he disappears. Virtually disappears from these little 4-year and 3-year-old children with no contact. He could have, called them as of, I believe it was August of 2021. He had the phone number at the foster home. There was no contact with him. So from these children's point of view, not only is it traumatic, but he's been abandoned. Now they've been abandoned. They did say they enjoyed their few visits with him before the final decision and of the court, but they don't really, the little one couldn't even really say he remembered his dad. The time has gone on so long. And to Judge Lindley's point, I guess the last thing I'll say is that, when there's plenty of case law out of this department that when there is a conflict between the right of a parent and the best interests of the children, the rights of the parents must yield to what's in the best interest of the children. And at this point, I'm sorry,
Judge.
Judge?
What you're saying in closing, it sounds like what you're saying is that you are advocating the positions of your clients. You're not substituting judgment. You are saying.
I don't think my clients have an opinion, Judge. I think they're too. It's the older child that has the learning disabilities. He does have an IEP. And the little one is I think they're both very scattered, immature, certainly for their ages. I've, dealt with probably 1,000 kids as AFC now. They seem very immature. So
you are substituting for them on the issue of the suspended judgment was why I'm asking. You're not saying that they don't want to have a suspended judgment. You're saying that you're substituting judgment for them, and you're saying it's not in their best interest to have a suspended judgment for the father.
That's correct, Judge.
Okay.
They need permanency.
Very good. Thank you, counsel.
Thank you.
Case 281, 282, and 283 in the matter of Jasmine L., Mantu L., and Vanessa M.R.
Can you hear me?
Yes, counsel, we can. Can you hear us?
Yes. Do you want me to turn the light on a little bit brighter in my room and maybe a little
You're
darker?
fine, counsel. We can see you fine. Mr. Mannion, can you hear us?
I can, Your Honor. Thank you. Can you hear me?
Yes, we can. Very good. Please proceed.
Okay, thank you, Your Honors. I'm representing Mantu L., who was adjudicated to have neglected the 5 subject children. Of the 5 children, he's the biological father of 4 of them, and he's the stepdaughter to the eldest, who is Vanessa, who is now legally an adult. Before I get to the substance of it, there's one point in Mr. Mannion's brief I wanted to address, and that the idea of preservation. weight of the evidence is the only issue that I raised in my brief. And that issue does not need to be preserved because it's factual. So you don't have to object to any kind of weight arguments during the trial. I mean, because the purpose of the appellate courts is to review the facts. I mean, I would agree. Other issues like sufficiency of the evidence were never preserved, and those types of issues do need to be preserved according to 5501 of the CPLR. So I just wanted to just make that clarifying point. I'll be happy to answer any questions about it if you wish. Otherwise, as far as the substance goes, I like I would ask very respectfully that the appellate division take notice that the caseworker, Jacob Dorman, was not diligent in investigating the allegations against Montu, who is the entire case against Montu turns basically on an anonymous phone call made from a landline to the Cheektowaga police and the uncorroborated statements of a 10-year-old child, that would be Wakel, who was at the time in 2018, 10 years old. Mr. Dorman interviewed Wakel also without his parents' permission. The mother is Amanda Goss, but she's not involved in this proceeding. More specifically, the underlying events, Your Honors, took place on April 15th, 2018, almost at this point, 6 years ago. The video that Montu presented into evidence when he was representing himself at the trial did not show that anybody in this family was afraid of him. I mean, Tiara was heard screaming at the police as to why the Cheektowaga police had broken into the house, as to why they were taking his father away. Amanda, the mother, was alleged to have a bruised lip, but when you look at the video, she didn't have a bruised lip on the video on the night that all this was going on. Mr. Dorman admitted during the trial that after Montu went upstairs, it was a two-story house. Nothing at that point was preventing Amanda and any of the children who were on the downstairs portion from just leaving. We would also point out, Your Honors, that Mr. Dorman did not immediately file a neglect petition against Montu because the police had already removed him from the home. We also point out that there was a parallel case going on in Cheektowaga, but I think he was eventually acquitted of that, or it was just dismissed. So, but in any event, Mr. Dorman never followed up with Cheektowaga as to what became in the justice court there. And also, so there was this delay, Your Honors, in filing the neglect charges against.
Well, Counselor,
yes.
That delay was about a month.
About a month, yes.
Right, and your client was incarcerated during that time. That's how Dorman explained the delay.
Right, but
Right.
if he was, well, that's how we explain the delay. But why the delay? I mean, if he was neglecting the children and the evidence was just so there, just file them immediately. What was the purpose of a 30? He doesn't have to wait until he's non-incarcerated to.
Well,
I mean,
they were in the process of interviewing the children who cross-corroborated each other that your client had an axe and swung it at one of the children.
I don't think the cross corroboration was nearly as strong as it could have been. I mean, he attempted to interview Tiara, one of the daughters, but she refused to speak to him. I mean, Vanessa made various allegations, but they never offered her statement to the CAC from the Child's Advocacy Center into evidence. So you're left with what exactly did the 10-year-old, what did he say that was corroborated? And that's why he swung an axe, but to whom? And then they may have found an axe in the house, but that doesn't prove that he used it. I mean, there was no video. I mean, the video doesn't show him using the axe against anybody. So, I mean, how strong was the corroboration? I mean, in any event, can you use the hearsay statement from one child to corroborate the hearsay statement from another child? I mean, that just seems to be presents a double hearsay problem. And although I agree that 1046 AV6, I believe it is in the Family Court Act, allows the caseworker to take the stand and say, well, this is what the child told me. But that still has to be corroborated, Your Honor.
Counsel, was it appropriate for the court to find that the untreated paranoid schizophrenia was a risk to the children?
I don't don't think, I mean, my client's very, very strongly opposed to that idea. I mean, I think that he was, you know, I think he disputes that he even has that diagnosis. And I think he's also made it very clear that he's opposed to the idea that the judge, who's not a psychologist, could somehow diagnose him of this or use this as evidence against him. But in any event, I don't, I mean, I guess to maybe answer your answer more, sorry, more directly. I don't think having, even if we were to start with the assumption that he had paranoid schizophrenia, I don't think that standing alone is proof that he neglected the children, whether it was being treated or not treated. I mean, I think there has to be some nexus that says, well, okay, well, he has this disease or this mental defect, and because of this defect, he's treating the children, or he's done something that's putting the children in harm's way. So, I mean, I don't think that nexus was ever really firmly established based on, it was basically a one-time event occurring on April 15th, 2018. Did I answer your question?
I guess so. The one piece about the event we haven't talked about is that in my notes, he choked Ms. Goss, who at that time was 3 months pregnant with Jasmine, the derivative child, until she was unconscious. Does the record reflect that that didn't happen?
Well, I think he's actively denying that happened. And also when Vanessa, I believe, told Mr. Dorman or caseworker Dorman that she heard a noise, but she didn't, when she went downstairs, she didn't actually witness the domestic violence. And I think when Amanda took the stand, who, by the way, was called by called by Monsoon, who I think she pretty much denied that any of that happened. So I don't know if that answered the question.
Yes, thank you.
Okay.
Anything further, counsel?
Let me just look my notes. Just overall, though, that the weight of the evidence does not preponderate towards Montu neglecting the children, and our position is that the Fourth Department should vacate that finding and dismiss the underlying petition.
Thank you, counsel. Mr. Banion?
Thank you, Your Honor. On behalf of the Erie County Department of Social Services, Benjamin E. Mannion, right from the get-go, I would just like to clarify for the record that as far as the mental health issues, that was what Appellant admitted to on the record. He testified that he had untreated mental health issues, and as the record illustrates, there is a nexus that exists. That nexus occurred in April and also occurred in the many other allegations that were made, such as Appellant apparently sexually harassing and sexually assaulting his stepdaughter, Vanessa, which she admitted to in a police report and then was also testified to at trial. Going to Justice Nowak's contention about the court properly finding the untreated mental health issue, it's the department's position that there is a nexus there, that there is more than sufficient evidence for the court to find by a preponderance that the untreated mental health was a risk to the children. And as to the choking of Ms. Goss, while the record does reflect properly that there was no direct observation of that event, there was circumstantial evidence. I believe there was a statement that was made through the caseworker that was not objected to as hearsay, that Vanessa came downstairs and saw Miss Goss lying on the floor of the house. And then I believe there was another statement made by Appellant to Vanessa that said, "This is what you do to the ones you love." So while the department fully admits there is not video, however, there was more than sufficient circumstantial evidence, which was corroborated by multiple sources, including I believe Wakel, who said that he was concerned about his mother, to find that the mental health rises to the level of neglect in this case. Also going back to Justice Del Conte, the delay was only a month. I would also note too that to the best of the record's reflection, social services personnel did not arrive on scene with Cheektowaga police. So to equate this to a police investigation where DSS was on the scene, was conducting the investigation already, and could issue the neglect petition right there on the spot as though they were the police, is a false equivalence that should not be accepted by this court. Finally, as to the preservation issue, The department stands by its contention that weight of the evidence must be preserved by the appellant moving to dismiss the case at the end of the petitioner's case in chief for failing to present a case. And that is held out in numerous areas of law throughout this state, whether it be criminal, whether it be juvenile delinquent proceedings under Article 3, and the appellant failed to do so in this case. Therefore, his argument is not properly before the court. Even if it was, there is a sound and substantial basis for this court to find that the appellant neglected his children in this case and derivatively neglected his afterborn child. Pending any questions from the court, the department will rest on its papers to the rest.
Thank you, counsel.
Thank you very much.
Case 284. BL Doe 5 versus Fleming. Okay, terrific. We got both counsel. Counsel, I'm going to give you a heads up. Because we have you both on a companion case 289, we're going to call this case first, finish it, and then we will switch right to and take out of order 289.
Okay, thank you, Your Honor.
Very good. So apparently you can hear me, and I think I just heard Counsel Nelson. Counsel Bonsbach, can you hear us?
I can, Your Honor. Thank you.
And we can hear you. Please proceed.
Good morning, Your Honors. Amanda Nelson, here for the Rochester City School District. Of the remaining claims that plaintiff has interposed against the school district, it is crucial that plaintiff demonstrate that the school district had notice of the specific propensity of Mr. Fleming to sexually assault or abuse students. With respect to BL Doe 5, the plaintiff in this issue, plaintiff relied almost universally on plaintiff's statement that 50 years ago, she had a conversation with Moses Cofield, who was also a teacher, at which time, after school hours, off school grounds, he advised her that he knew, quote unquote, what was going on, and she should be nice to him if she didn't want it to get out, at which point he himself proceeded to attempt to sexually assault her. Plaintiff said she didn't know what he was talking about and started crying, and he drove her home, and that was the end of it. He did not tell anyone at the school district what he suspected. That this forms the basis for the court's denial of the school district's motion for summary judgment demonstrates the impropriety of the decision on several levels. To begin, just the statement in general is vague. The statement as conveyed by plaintiff is vague. It only speaks of he knows what's going on. Doesn't say exactly what he knew. It said that she said that he told her he heard them. No indication as to what exactly he heard, when he heard it, how he heard, especially when plaintiff herself said that she could never hear anything going on in the neighboring room. Now, also bear in mind,
Counsel, you don't think it's fair for us to take it that what the statement is that he knew there was an inappropriate relationship going on between the plaintiff and Mr. Fleming?
Well, I think it leads to a fair amount of speculation. I mean, I think it's certainly a fair leap, absolutely. But I think there is a question of, he just said, I know what's going on. And she herself said that she had never heard anyone there before. But then even adopting the expectation that, yes, it was, I know that there's an improper relationship here, the statement itself was still inadmissible as hearsay. And it should not have been relied on. The court relied on.
It comes down to, it's clearly offered for the truth of the matter. It comes down to whether it's admissible under
Right.
CPLR 4549, this new statute. And if you want to address that.
Yeah, absolutely. As you mentioned, it's recently been amended and it's based on Federal Rule of Evidence 801 D2D. Something crucial with that is that A, it's plaintiff's obligation to, plaintiff carries the burden to demonstrate that the exception applies, but also part of that exception, you can see it in Krause v. City of La Crosse, is that the statement had to have been made while the speaker was acting in the course of their duties for their employer. And here, this court has already determined in BLDO 5, as issued in 2021, that what Cofield was doing 9 o'clock at night at a park off school grounds was certainly not part of his school duties.
If Mr. Cofield had said it to the plaintiff at the school, said, look, I'm hearing things, I heard some things, so forth and so on, then it would be admissible. Would you agree?
No, I would not. Even in that situation, I think it would still be inadmissible because he was clearly using his professed knowledge, assuming that he even actually had that knowledge, using that professed knowledge to himself conduct its work.
I'm sorry. Yeah, if he just come up to her in school without trying to take advantage of her sexually himself, just in school, say, look, I've heard this, then that's clearly in the scope of his employment and would be admissible under the exception to the hearsay rule.
I think under that scenario, yes, it would most likely be admissible. It would most likely satisfy the exception.
So the problem is now the purpose by which he's using the statement. That if he was even at night, he's offering her a ride home because he's worried about her safety as a student. If he takes her aside in the car and says, listen, I know what's going on with you and Mr. Fleming, I really think that's bad for you. I really think you should stop that activity. I think you should report it to the school. I'm caring for you as a professor, student. You take away his desire, his improper purpose. Then is it okay? Is it the fact that he had this other ulterior motive, the problem?
No, I think it would still because then you're looking at it being beyond the school district's responsibility, beyond its ambit of control. I think there would still be a separation.
It's not in the scope of a duty of a teacher to look out for the welfare of a student that he or she thinks is being abused.
It certainly is. It certainly is. And in this case, on the facts at hand, I don't think that there's any dispute that Mr. Cofield completely abandoned that duty to both her and to the school district.
Let's say we agree with you on that. There's other evidence, though, that the plaintiff that's in the record with respect to conversations that the plaintiff had with her school counselor. The counselor was inquiring about this matter and she shut down, and then the counselor, is that enough to put the school or to put the counselor on notice that something was awry here?
I don't think so at all, because here you're talking about due to the plaintiff's increased absences, the school district, she had already been assigned a guidance counselor and then separately assigned also a social worker or a psychologist. And the social worker specifically spoke to her about these absences, and she came up with excuses. She said, I don't want to graduate. I had forged these passes. I told my gym teacher that I wasn't able to attend this day, etc. And then when the psychologist specifically asked her, why are you spending so much time in the music room? Why do you go there? And she said, well, I like the paperwork that I'm doing. I like being involved in this. I don't think that raises any potential issue of impropriety, especially when here she's given an open forum to say that there's something going on, that there's some sort of impropriety. And instead she gave these very rational reasons for why she's doing what she's doing.
My understanding of the record was that she, when asked questions targeted toward Mr. Fleming and why he spent so much time there, he got a lot of paperwork in his office a lot. It was more she shut down and didn't want to discuss the matter.
She said that she personally shut down and didn't want to discuss it. She personally felt that she couldn't say it. But coming from the hearer's perspective, He doesn't know what's going on inside her mind. He could only hear, I like the paperwork. I like being part of this music program.
Counsel, let me ask you this, and looking at this from the point of view of an ordinary prudent parent who's in that same situation, who hears that we had to get a counselor involved, right? And the counselor's attempting to interview her, and she's shutting down, and there's absences that were not previously shown in her school record, that now she's absent from school. Does an ordinary prudent parent say, time out, there's something going on here, we need to drill down further on this? And does it matter that we have other testimony in the record about how, there's really a lack of crossing the T's and dotting the I's when it comes to these kind of events back in the 70s when we're talking about, as opposed to later on? Did the school district do everything it was supposed to do and everything that would be expected of a ordinary prudent parent?
Sure. And I think in this instance, they did that when she gave, or if anything, when she gave the explanation that I don't want to graduate, like this is where I want to be. I certainly don't think that would give even an ordinary and prudent parent any indication that she is being sexually assaulted, that it takes that next leap to notice of an improper proclivity by Mr. Fleming.
Do you think, counsel, when it comes to the analysis of that, whether or not that she was shutting down, whether or not they drilled down far enough, is that a jury question?
I don't believe it.
Could reasonable people disagree about that and discuss that and say, yeah, maybe they should have done more, maybe they shouldn't have done more? Isn't that the whole purpose of a jury, to hear the testimony and let them make the decision?
Well, I think when you're at the point where the jury is hearing only what the school district heard, only what she conveyed, then I think there is no jury issue. And I think it really comes down to a matter of law. If we're just basing this entirely on the fact that she was missing classes, and then she gave reasons for why she's missing classes. She didn't want to go to gym. She, did not like the English teacher at that time. I think it doesn't seem so.
Does an ordinary prudent parent take as gospel what their high school children tell them without drilling down if there's reason to drill down in their mind?
I would certainly assume.
We have an answer, we're done, and that's what an ordinary prudent parent would do?
I would certainly assume not, but it doesn't lead to. Absolutely, there would be a question of why don't you want to graduate? Why, what's going on? And then she did improve in school. But to make the leap that this must be because a teacher is molesting you, that this specific teacher, it doesn't. And then there's also sort of the side issue of the fact that none of this happened during school hours. And I'm not saying that separately is in support of our argument of a reasonably prudent person over a reasonably prudent parent, but that if the issue was, oh, you're cutting these classes during the school day, nothing untoward was happening when she was cutting those classes. Even when she was spending time with Fleming or performing the administrative tasks for him, no, they were not having sex at that time. There wasn't anything improper. So I think it is too far afield to put before a jury, well, maybe that because she had missed classes and because she was feeling like she didn't want to graduate, the school district might have had notice of this improper proclivity.
We also have other evidence in the record, it seems to me, with respect to Fleming concerning, and other students having witnessed this, him stroking female student hair while in school, rubbing their backs, embracing them, kissing them. I mean, doesn't that give rise? Wouldn't an ordinary prudent parent look at that conduct and say it's time to drill down on this a little bit? What's going on here?
Well, in this instance, all of that happened after this plaintiff had graduated, and that all happened also at a different school. So it wouldn't have been something that would have been, I think, even on a reasonably prudent parent's radar. to start focusing on Mr. Fleming.
Any further, counsel?
I just briefly to speak to the, actually, no, thank you, Your Honor, unless the court has any further questions at this time.
No further questions. Counsel Bansback?
Thank you, Your Honor. John Bonsbach, co-counsel with Christopher J. O'Brien of O'Brien and Ford, attorneys for plaintiff respondent. Mr. O'Brien is viewing this oral argument. With respect to the pass issue, I think the bigger question is, as I believe Judge Whalen suggested, is why is my child not in the class that they're assigned to be in? And it's great that someone from the school went out for some unknown reason that's not in the record to talk with this person about her absences, but there's nothing showing that any solution or any result was ever achieved by this meeting in terms of causing the plaintiff to actually start attending her English class, which as a National Honor Society student, she gets an E in English her last marking period, and she gets an E for the entire year in gym class. How do you flunk gym? I suspect maybe one of the only reasons might be you're not there. And that seems like something that any parent would have wanted to know. Why is my child not in the class that their schedule says they're supposed to be in? That's a pretty fundamental question. But related to that is our belief that the school district didn't have policies or procedures about why what was supposed to be done about sexual abuse and what was to be done if someone suspected it had happened. There was no training. There was nothing of that sort. This court affirmed the court below in Niagara County, Judge Chimes, her PB 36 Doe versus Niagara Falls City School District, where she denied the school district's motion to dismiss a negligence cause of action, specifically noting that allegations of a failure to train students, parents, and staff about the risks of sexual abuse and the failure to have policies in place to oversee the abusive teacher were a basis for her decision. And we have the same fact pattern here. The record is completely lacking of any sort of policies, procedures, training of anyone about what could have been done. And there's other cases mentioned. It's in I believe our brief, Davila versus Orange County, where it, in denying a motion to dismiss, it said plaintiff sufficiently alleged that the district breached its duty to plaintiff inter alia, failing to implement and enforce adequate procedures to protect the plaintiff from sexual abuse. That would be without even notice. That would just be an obligation of general supervision by the school district to protect its students. Going back to the Moses Cofield statement, our position is first that under the recently added CPLR 4549, it isn't hearsay because the two elements that 4549 requires are both present. It's by the opposing party's agent or employee. That's Moses Cofield. He's a teacher. And it's on a matter within the scope of that relationship and during the existence of that relationship. The scope of Mr. Cofield's relationship, and I apologize, I forget which justice said it, but that clearly as a school teacher, he has a duty to protect students. And clearly during the time that he has this duty to protect students in that adjoining orchestra room that's next to the music room, he learns of this, and that's why he's an employee, which satisfies those two elements. The fact that it was
also, does it make a difference that when he makes the statement, he is well off the property of the school, and he's certainly not making it in his capacity as a teacher. He's making it in an effort to, I think, obtain some advantage over this young woman.
So I think, Judge Whalen, you just raised 2 points there. One is that does the location matter, and two, does his intent matter? And as to the intent issue, I think that the Kirshner case versus KPMG, the Court of Appeals decision that's cited like ad nauseum here, that case makes it clear that the intent of the speaker is irrelevant. Okay, what is important is whether the principal is the agent's intended victim. And I don't think even the school district will claim that Cofield's intended victim was the school district. If anyone was the intended victim, it was the plaintiff that was being subjected to this statement. As to the second statement about putting aside the intent, the location of the statement, with all due respect, it could have been a grocery store. It could have been pretty much anywhere, the statement is still meets those two elements of 4549. It's while he's an employee of the school district, and it concerns a subject matter that's within his obligation. The common law duty to report cause of action, which plaintiff concedes was dismissed by this court. It was dismissed because the statement at issue was made off of school grounds. That's to the common law duty to report. CPLR 4549 doesn't have an element requiring that the statement at issue be made in a school building, in a grocery store. It doesn't have that limitation. So we would respectfully suggest that the statement is certainly non-hearsay under 4549. Staying with that statement, even if 4549 doesn't apply, as we've pled, the statement at least shows his state of mind, which I believe would be an exception to the hearsay rule, or outside of it because it's not being offered for truth. It shows notice. And we're suggesting here that the school district still should have had knowledge that through its teacher, which should be imputed to it, that this teacher Fleming was sexually abusing students on school grounds during school hours. This idea that it was after school hours, first of all, the record shows that the abuse initially began during school hours when he first put his hands on her inappropriately. It was during the school day after he had written a pass to her for her to miss her gym class to be with him. Most of the other, certainly the acts of sexual intercourse, I believe that the school district is correct that the intercourse took place, the rape took place immediately after the last period of the day inside the music room at West High School. And again, under the orbit of authority view of this, our position is that until the plaintiff has returned to her parents, the school district remains in loco parentis. This is a continuous, she shows up at school, they have responsibility for her until she leaves that school building. That's their duty, to know where she is. And the fact that they don't know where she is and that they don't seem to have an interest in why she's missing gym class or English class is what really troubles us.
Thank you, counsel.
Thank you, Your Honor.
We're now going to shift to case 289, BL Doves 2 versus Fleming. Counsel, proceed.
Apologies. Yep. Thank you, Your Honor. Amanda Nelson for the school district. Again, so in here,
a lot of the arguments are the same, right?
A lot of the arguments are the same. In fact, they're based on the very same
facts
testimony.
differ a little bit as between the two victims.
Right. And then the only thing that I would touch on, unless the court has questions, of course, as far as the Cofield statement and the notion that would be that what he purportedly knew or heard should be imputed to the school district, is that there are cases, much more similar fact patterns that are more applicable here than the Kirshner standard, that unless there's fraud or embezzlement. In fact, since these briefs were last submitted, the third department has also issued a decision in Baris versus Erie and Niagara Insurance. Citation I have is 2024, New York Slip Op 01133, where the agent concealed the information from his principal, and the court determined that there can be no imputation in that. Similar to AM, similar to Christopher S. Here, there's no question that Cofield hid the information from the school district, specifically offered to hide it, to, as you noted, take advantage of plaintiff, and therefore it should not be imputed. The secondary evidence which plaintiff relies on is actually based on testimony from another case, BL Doe 3, and largely BL Doe 3 statements that she told teachers, I don't like Fleming, he's too touchy-feely, he gives me the creeps. But where she admittedly did not tell anyone that he was improperly touching her during that time. And I think that really goes back to the issue that there must be some notice of the specific impropriety. There must be something clear. She had to say what was going on, not just
you would agree, though, counsel, that you'd agree, though, if certain flags are raised, the school district would have a responsibility to drill down on those. They can't just hear things and say, well, they weren't specific, so we're going to shut this down, this interview down, and send her on her way before we learn too much. I mean, certainly that's not the case, right?
That is not the case, certainly. You
So
know,
there are situations where the school district would have responsibility to follow up and to drill down on issues because that's what an ordinary prudent parent would do.
certainly.
Okay.
Yeah, no, absolutely. I can't argue with that.
And you're saying the school district did all it could do in this instance.
I think in this instance, it took every step that would be expected of it. That when Bialdo 3 said he's too touchy and, you know, I don't like to be touched, without saying anything further, without giving an idea of what she was meaning or what she was conveying, the school district would not be expected to go further.
Very good. Anything further?
Unless the court has any further questions, we would rest on our briefs.
No questions. Thank you. Counsel?
Yes, John Bonspach for plaintiff, along with co-counsel Christopher O'Brien. With regard to the touchy-feely comments by Bialdo 3, I believe that's a jury question. We cited some case law saying that that's enough to create a question of possible notice, and we would rely on that. With regard to this particular plaintiff, Bialdo 2, she's the woman that was removed from class while class is going on, while there's a piano accompanist in the class, on a number of occasions. I think she says more than 20, to be put alone in a room with Fleming behind a closed door, ostensibly to do clerical tasks. And while she's doing those tasks, Fleming's inside the room behind the closed door while the accompanist or a student is running the class, and he's groping her, he's touching her, he's asking her to come out to his RV, and there's no sexual abuse, no sexual intercourse, there's no rape alleged, but certainly there's a sexual abuse within the meaning of Penal Law 130. The other piece that's different about the Bialdo 2 case, as opposed to the prior one, is that there is a common law duty to report cause of action. And our position is that, as expressed in our brief, is that the district didn't report its actual notice that Fleming was sexually abusing any of these plaintiffs, not just BL2, not just Bialdo 5. They didn't report any of it to law enforcement, despite the Moses Cofield statement back in '69 about he knows what's going on in the back office, the music room, which should have been imputed or should be imputed to the district, as the court below found. And then in 1972-73, when Bialdo 3 is telling 5 different teachers or administrators about Fleming's being too touchy-feely and complaining about him. And then thirdly, in 1979, when another music teacher at the school district, Terrell Watson, walks in on seeing Fleming being screamed at by the piano accompanist who's accusing him of having fondled a student in a practice room. None of that is reported by Terrell Watson, but there's testimony in there that by Terrell Watson that the accompanist, Grace Trebert, did report it to the school district. We have no record of that in any of the papers, which perhaps isn't terribly surprising because we have no record of Fleming ever working for the school district other than a salary card. There's no record of his letter of resignation. There's no personnel file. It's just this naked salary card, which kind of lists his dates of employment, the school he's assigned to, what his pay grade is, and what it's based upon. So there certainly is all kinds of notice that should have caused the school district to report the sexual abuse of Bialdo 2 and later people to law enforcement. And our claim is that the result of not reporting it is that had it been reported to law enforcement, there would have been an investigation. There would have been publicity. Like here, there might have been a newspaper article that appeared finally in 2019. And this plaintiff, this Bialdo 2, wouldn't have worried from all these years from when she graduated, when she graduated from East High School in 1974 until 2019, that she wasn't the only girl that had been stupid enough and afraid enough not to stand up to Fleming and report his abuse. She was just one of many. And that had she been earlier communicated that she wasn't the only one, maybe she would have gotten some help and she would have avoided a lot of the emotional harm that she suffered from her graduation in '74 until 2019.
Anything further, counsel?
Nothing, Your Honor.
Thank you.
Thank you.
Counsel. Case 286, Levine versus State of New York. I believe we have all counsel here, a full lineup. Mr. Valentino has submitted. Mr. Buckeye, do you want to proceed?
Yes, I would, Your Honor. Craig Buckeye on behalf of Governor Kathy Hochul as a respondent in Levine versus State of New York. This appeal concerns the constitutionality of Executive Law Section 94 insofar as it allows certain legislative leaders, both majority leaders, minority leaders, and the governor and the attorney general and the controller of the state of New York to make nominations of persons to join the newly created, as of 2022, New York State Commission on Ethics and Lobbying in Government, whereby those nominations would only take effect as appointments if those individuals were to be approved by a group of the deans of the various ABA accredited law schools in the state of New York. And I think where we need to start is with respect to the standard that needs to be applied in this case, which is that the legislation at issue has a strong presumption of constitutionality, as
Mr.
per
Buckeye,
the White v.
Mr.
Cuomo
Buckeye,
case
could
from
I,
the Court of Appeals.
Mr.
Yes,
Buckeye, could I
Justice
ask you this?
Lindley.
Could we start even before that on standing? Because if he doesn't have standing, we don't get any further. And I understand you have two standing arguments. One is that he's ineligible, Mr. Levine, because he served on JCOPE within 2 years. But you're also arguing an alternative, I believe, that even if the 2-year period is up, which it may be now, or if he was never on JCOPE, he doesn't have standing because the only people here who would have standing are the senators. His argument is that this is subject to advice and consent. He's not a state senator. So is it your point that even if he hadn't been on JCOPE, the only people who have standing here are those in a position to give advice and consent, which would be the senators?
The only persons who would have the ability to raise a challenge here would be the individuals who are the nominators of the persons who would be able to serve on the new Commission on Ethics and Lobbying Governments. So, for example, excuse me?
That'd be Senator Ort would be the only person.
No, not necessarily. Senator Ort could, Assemblyman Barclay could, Speaker Heastie could, Senate President Stuart Cousins could, the governor, the attorney general, the controller. These are the individuals who are making the various nominations, and their ability to make the nominations that they choose is limited under the statute insofar as the group of deans of the ABA accredited law schools in New York State need to be able to confirm those nominations and actually appoint the individuals who are going to be serving on the commission. And so what we would submit is that standing is a two-step process. First of all, there needs to be an injury. And second of all, the person who is injured needs to lie within the zone of interest of the injury. And I get what Mr. Levine is saying, that he was nominated and he would like to serve on the commission. And because the group of deans did not confirm his appointment to the commission, as a consequence, he isn't able to serve. But then the second aspect of the inquiry is, does he lie within the zone of interest that's protected by the statute? And we would submit whether Mr. Levine served as a member of the commission of the predecessor JCOPE, Joint Commission on Public Ethics, that's really immaterial because he wouldn't be within the zone of interest, because the person whose discretion is being limited would be the individuals who would have the power to nominate, and absent the need for confirmation by the group of law school deans, they would be able to nominate whoever it is that they want.
Counsel,
Yes.
let me back up to Justice Lindley's question here. Assemblyman Barkley wasn't nominated.
But he
wasn't nominated to serve on the commission, but the plaintiff here was nominated.
Yes.
He had that unique position. And would it be your position here that the plaintiff would not be able to bring in Article 78 if his contention was that the IRC had acted arbitrary? He couldn't bring that claim?
Well, in fact, when he originally commenced this action, he did have a cause of action alleging that as applied to him, the procedures of the commission were used in such a way.
I'm sorry to interrupt you. I just want to stick with standing here for a moment.
Sure.
I mean, would you agree with me that he could bring in Article 78 if his contention was that the IRC had acted arbitrarily?
In fact, that's what Mr. Levine originally did in his second cause of action.
And so let me finish that point then, if I could. I'm sorry to interrupt you. If you could bring in Article 78, couldn't he have brought in hybrid action where at the same time he challenges the constitutionality of the entire process?
I would say that it really depends upon what the nature of the claim is. And in this case, the nature of the claim is that the appointment method that is used is unconstitutional. And we would submit that the only individuals who lie within the zone of interest of making that claim, of offering that claim, would be the persons who would have the authority under the statute to designate individuals to join the commission. And that would be the legislative leaders, the governor, the attorney general, the comptroller. And then, notwithstanding that issue, we would submit that when Levine was designated back in 2022, that he was prohibited on the way that the statute reads because he had served as a member of the predecessor Joint Commission on Public Ethics within the previous 2 years. So he wasn't qualified for appointment to the new Commission on Ethics in Lobbying and Government regardless.
But he is now, right? The 2 years has come
the
and
2
gone.
years, as I understand it, the new law was enacted in April of 2022. It took effect in July of 2022. So if one were to go 2 years from July, there would come a point in time in the summer when the 2 years would have elapsed, yes.
Anything further, counsel?
Well, what I would like to address is with respect to the actual merits. There's a high burden that the plaintiff needs to satisfy. There's a strong presumption of constitutionality of this statute. The legislation is stricken only as a last unavoidable result after every reasonable mode of reconciliation of the statute with the Constitution has been resorted to, and we would submit Mr. Levine has not satisfied that standard because of the fact that this case can be decided based upon settled principles of law that have been handed to us by the New York Court of Appeals, and in particular the case, even though it's a very old one, it's absolutely on point, is Sturgis v. Spofford from 1871. And that was a case concerning a board of the state of New York that still exists. It's the Board of Commissioners and Pilots that governs the licensing and the supervision and the training and monitoring the safety of the individuals who serve as pilots in the various waterways in the state of New York, including around the harbor of the city of New York. And that's set forth in Navigation Law, Section 87, subparagraph 1. And in that case, it was alleged that the fact that members of that board could be appointed directly by presidents and vice presidents of the New York City marine insurance companies, that was somehow an improper delegation of authority. And we would submit that Sturgis is on point because Sturgis rejected that argument. And we would say that here, yes.
Mr. Buckeye, as you know, what Mr. Levine, he distinguishes Sturgis and Lanza, which I'm sure you're about to get to, is Sturgis is an appointment case. Lanza is a nomination case, power of nomination. He argues that this is power of advice and consent. That's what distinguishes this case from Sturgis and Lanza. But if Article 5, Section 4, because this is all coming under that provision, if you just look at that, if you read it first time, you think, oh my God, this does apply, right? It seems kind of, but then when you look under the hood, under those cases, it only applies to heads of departments. So
Absolutely.
wouldn't all these arguments, Lance Surge, if it doesn't apply to this position, we don't get into any of that, right?
I would agree. Absolutely. Article 5, Section 4 means that there's advice and consent with respect to choosing who the heads of departments are. There are 20 departments in state government, the Department of State being one of them. But here, it's clear under the statute that the new Commission on Ethics and Lobbying in Government is a subsidiary component within the Department of State. And so advice and consent doesn't apply because this commission itself is not one of the 20 departments of state government.
And that's the ruling from Appellate. The trial judge did an exhaustive, very well-written analysis of that issue.
Both the trial judge, yes, Your Honor, both the trial judge in Appellate and the second department affirmed on the reasoning of the trial judge in Appellate, which we would submit is absolutely applicable and remains so. The one more thing that I would like to reference is the fact that we did get, and I believe there's an attorney from Mackenzie Hughes who's going to be arguing, we did get a brief from the Mackenzie Hughes firm on behalf of Senator Ort and Assemblyman Barclay, setting forth substantive arguments in support of the position of the plaintiff, Gary Levine. And what I want to emphasize for this court, in as much as this court is going to consider anything that the Mackenzie Hughes firm has to say, is that all of the arguments on behalf of Senator Ort and Assemblyman Barclay have not been preserved for review. And that is coming from the case of Kavanaugh v. Kavanaugh, 200 AD 3rd, 1568, from this court in 2021. We didn't have an opportunity to brief this issue because we received the brief from the Mackenzie Hughes firm on the same day that we filed our own brief. And what one needs to do is take a look at the record to see what the Mackenzie Hughes firm said before the trial court. All they said, this is page 35 of the record, is that the minority leader defendants do not object to plaintiff's request for relief to the extent he demands to be seated as a member of the Commission on Ethics and Lobbying in Government. And then at page 858, when we had oral argument before Justice LaMondola, Mr. DiPilato from the Mackenzie Hughes firm, all he said was, so as we have heard, Senator Ort is the one who nominated Mr. Levine, and Minority Leader Barclay also supports the appointment of Mr. Levine, so we welcome any ruling that would result in the appointment of Mr. Levine. The Mackenzie Hughes firm did nothing more than simply offer generalized support for Mr. Levine's causes of action, and now, for the first time on appeal, they offer a whole litany of substantive arguments that they hadn't offered before, and we would submit that those arguments haven't been preserved for review.
They are named defendants in this proceeding, not plaintiffs. Your position is they want to commence their own action. Sounds like you think they would have standing, and they can make these arguments if and when they want to prosecute their own case. They can't do it in this context.
No, actually, they could have before the trial court level, except they didn't. And what the Kavanaugh v. Kavanaugh case stands for, and actually Justice Nowak was the trial judge in Kavanaugh v. Kavanaugh, it was an intra-family dispute concerning the purchase of a family business. And in that case, what one of the defendants had tried to do was simply to offer generalized support for a certain position taken by another party, and simply tried to, and I'm quoting this court in its decision from 2021, incorporate all the arguments submitted by his allied co-defendants in the litigation without identifying those arguments and explaining why they availed him particularly. And it was determined that that alone did not suffice to preserve present arguments for appellate review. And that's the same thing that happened here. And we would submit that there should be no countenance given to any argument offered substantively today on behalf of Senator Ort and Assemblyman Barclay. They had an opportunity before the trial court to make their arguments, and they simply did not. And the last thing I would like to...
Counsel, you need to wrap up.
The last thing I'll say is that with respect to the Cuomo decision from Justice Marcel in Albany County Supreme Court, we would submit that case, first of all, deals with the delegation of executive power rather than legislative power. And in as much as it says in dicta that somehow the appointment mechanism at issue here was not proper, it relies upon concurrences and dissenting opinions from some U.S. Supreme Court justices. It doesn't rely upon any cases from the state of New York, and nowhere is there any discussion of the Sturgis case or the Lanza case that we submit are dispositive, and we submit that the motion to dismiss was properly granted.
Thank you, counsel. Counsel, want to proceed? Mr. Slay, I have you up next.
Thank you, Your Honor. Can you hear me?
I can.
Thank you. May it please the court, Carl Slade from the law firm of Lippis Mathias on behalf of the Independent Review Committee for the IRC. And the IRC is comprised of the deans of the 15 accredited law schools located throughout the state of New York. For my allotted time, the IRC would like to highlight what the IRC believes are significant threshold issues of standing and capacity, which obviate any need to address the substantive arguments, lacking as they are, being appealed by appellate. On the state constitutional issues, unless the court has specific questions, the IRC will rest on its brief and join in the arguments of the governor. Finally, and I think this is very important, the legislative effort on behalf of the public here is important to keep in mind. Ethics scandals have been a cloud over the state for 15 long years, matched only by the epic failures of prior iterations of state ethics regulators and enforcement. This structure, for the first time, infused a degree of independence into ethics enforcement. And through the IRC, this solution by the state legislature and Governor Hochul is the true crux of the case, not any one person. The IRC has a very simple and straightforward mandate. Pursuant to the Ethics Commission Reform Act of 2022, and in the best service of public spirit, the 15 deans serve as an independent body to review and approve the nominations by elected officials vested with the appointment power. After the official makes the nomination, the state police conduct a background investigation, a public comment period occurs, the nominee is interviewed by the IRC. The IRC reviews references and records from the nominee, and then the IRC meets and votes on whether the individual should be approved. Here, Mr. Levine was not approved, along with the nominees of the Attorney General and the Speaker. If disapproved, the elected official or the appointing authority nominates another individual, and the vetting process repeats. Here, Minority Leader Orr nominated the appellant, who the IRC unanimously voted to disapprove, in large part based on his strident beliefs on issues from his service on the predecessor executive branch agency, JCO. And notably, that prior executive branch service is another separate reason that makes him ineligible. So on the issues of standing and capacity, the IRC raised these in detail at the trial court level. The trial court acknowledged the issue, but we submit prematurely waded into the state constitutional argument because Mr. Levine had no standing to bring these claims. If we step back for a moment, and it's puzzling on its face to see a nominee for a government position file a lawsuit to be seated in the position. It doesn't happen. And it happens, or it doesn't happen for a reason, and that's because nominees have no standing or capacity to obtain such relief. One cannot, and for good reason, litigate one's failure to successfully make it through a process to be a public officer. And this is a public officer.
Counselor, if I may interrupt you, wasn't that Marbury v. Madison?
Yes, I think so.
Right?
Right. And it's Marbury v. Madison, and it's been daily, and it's recently as 1987. And I think there's the case, which I think is helpful here to the court and instructive, matter of Sunbright versus Zoning Board of Appeal, 69 New York 2nd 406. And it said something more than an interest of the public at large is required to entitle a person to seek judicial review. The petitioning party must have a legally cognizable interest that is or will be affected by the determination. And that simply doesn't exist here. The appellant simply has no right to a position on the commission. Public officers are created for the public, not for individuals.
This was argued below by at least some of the attorneys, but we didn't get a ruling from Judge Lamondola.
He mentioned it. It was relegated to a footnote. I think it should have been much more prominently dealt with at the trial court level. The court certainly landed in the right place. It probably was a case of right church, wrong pew, finding that Mr. Levine didn't have this. But I think this case should have been dealt with on the issue of standing and capacity. Mr. Levine, there needs to be a zone of interest, as Mr. Bucky said. He has not established that at all. If you look at Mr. Levine's brief at the bottom of page 17, he simply states the two points and offers no reason why he is within the zone of interest or what harm he has suffered. There isn't any. And I think that's something that is worthy of significant focus. I would agree with Mr. Buckeye, maybe minority leader or other elected officials could satisfy that threshold requirement by arguing that it was their appointment, right? There was a bridge. They would probably be unsuccessful for other reasons, but that is not this case. I think the issue of capacity is worth note. And capacity, as the court knows, is different from standing. Capacity concerns a litigant's power to appear and bring a grievance before the court. And that ensures that the rights sought to be vindicated here by Mr. Levine would be asserted by a party that is entitled to have enforcement of that right. Mr. Levine is not entitled to enforcement of any right here. So again, the appellant fails and he has no rights to be vindicated.
Counsel,
Lastly, I'd like to—
you should wrap up, Counsel.
Thank you. Just one quick point on the deference to the legislature and the governor. It's well settled law that the acts of the legislature are entitled to a strong presumption of constitutionality. Here, that should be highlighted by the history of the past 15 years in our papers in the trial court level, in the record pages 240 through 249, exhibits E through O. We spend a significant amount of time discussing the failures and attempts to find an ethics regulatory body that would functionally work. But most importantly, Governor Patterson and others talked about the need to infuse some level of independence. It failed until 2022. The statute is sound. It passes constitutional muster. The appellant has no standing, and the court should uphold this law and reject appellant's claims to remove independence from the process. Thank you, Your Honor.
Thank you, Counsel. Counsel, I think we have, at least on my list, Mr. Pierce, you're up.
Yes, Your Honor. I hope you can hear me.
We can.
Alan Pierce of Hancock Esterbrook for defendant respondent Andrea Stewart Cousins. And I'm not going to take any time unless the court has questions for me. I stand on our brief and the arguments of my learned co-counsel.
Very good. Thank you, Counsel. Mr. Hunt?
Thank you, Your Honor. Brad Hunt on behalf of Minority Leaders Ort and Barclay. I think perhaps it makes sense for me to start by briefly addressing why you ought to listen to our arguments at all. In the trial court, we did submit an affidavit, stating that we support the position of Mr. Levine, but we did not submit any detailed briefing. I would submit to the court that at this point, we're dealing with a pure legal issue. This is not a factual issue, and the arguments that we have put forth in our brief are consistent and supportive of Mr. Levine's arguments in his complaint in the trial court. In his brief here, we just don't. The main difference is that Mr. Levine makes a specific argument about advice and consent, and we don't go that far to be so specific. But we're making very similar arguments that are basically addressed in the other respondents' brief. So I don't think there's any prejudice to anyone by considering these arguments on a legal issue.
Well, they weren't raised below, right? Well, you would acknowledge that you didn't raise them before Judge Lombardo?
We did not submit any memorandum of law or any detailed arguments below. We just said we support Mr. Levine, and it was Senator Ort who appointed Mr. Levine, and he remains the nominee today of Leader Ort. As far as standing, first of all, we believe that Mr. Levine clearly has standing. He has an injury in fact is because he's the one who would be on the commission, and if his position and our position is correct, and the independent review committee's veto power is unconstitutional, then he does have a right, a right to be on the Commission once he is nominated. So he has a right. Furthermore, the statutory provision that the governor relied on for the standing argument says that nominees are disqualified if within the last 2 years they served as members of an executive agency appointed by the governor. He was most recently appointed not by the governor, but by Leader Ort to JCOPE. So he does not fit within the terms of that statute. And it also is the case that as of July 8th of this year, the 2 years will be up anyway. So for all those reasons, we believe that Mr. Levine has standing. And in addition, Leader Ort is a party here, was sued as a defendant and has consistently in the trial court and in this court taken the position that we support Mr. Levine. So I believe while he's not a plaintiff, he also has standing. To briefly address the merits of this case, I think that this presents a unique situation in New York history, and it's not there's not settled law that governs this case. If you look, I think it makes sense to start by looking at the Lanza case, which was decided almost 100 years after the Sturgis case. And in Lanza, the Court of Appeals specifically said that it is unsettled whether the legislature can give appointment power as opposed to mere nominating power to a group of private citizens. Lanza specifically recognized that as an undecided issue. And what we have with the Independent Review Commission here is a combination of circumstances that are not found in any other situation that any of the parties has discovered in this case. And they make the Independent Review Committee of Law School Deans uniquely constitutionally problematic. And basically, those circumstances are three things. One, they have appointment power rather than nominating power. And there are a handful of instances of other boards through New York history where private organizations have been tasked with making nominations because they have knowledge in the community of who would be good nominees. That's the Lanza case specifically discusses that. That's not the case here. In addition, the second factor is that not only does the Independent Review Committee have appointment power, but it has appointment power that's exercised in the form of a veto. And that's never been done before, to our knowledge. There are a handful of other instances where private organizations can appoint some subset of members of a governmental board. And if you look, for instance, at the Public Administrators Board, the Indigent Legal Services Board, a subset of members of those boards are appointed by private organizations like the Bar Association. In this case, the Independent Review Committee actually can veto the nominees made by government officials, including the minority leaders. That's a unique situation. And the third factor is that the Ethics Commission is not a limited, specialized, industry-specific organization. It is a very important statewide board that has both regulatory authority, specifically under the statute, and enforcement authority, specifically under the statute. And nonetheless, it's not specific to the medical profession or the legal profession or maritime commerce. It's the general governmental lobbying and ethics regulatory body. And nonetheless, an independent review committee that is not only private, but is unaccountable and specifically made unaccountable by the terms of the statute has veto power over the nominations of government officials. So we submit that does violate the Constitution. It is an impermissible delegation of governmental power, whether it's viewed as legislative or executive, which is exactly what the Cuomo case, we believe, correctly recognized. And
Mr. Hunt, we'll take a hard look at that. You should begin to wrap up.
All right. And yeah, that's all. The only final thing I would say is that if you do strike down the Independent Review Committee, that doesn't strike down the whole statute, and it doesn't require this court to place in jeopardy any other New York organization, because again, this is a unique scenario. Thank you.
Thank you, Counsel. Mr. Ginsburg?
Thank you. May it please the court, Brian Ginsburg for Speaker Hasty. I'll try to be as brief as I can. Neither constitutional provision that plaintiff invokes here prohibits the legislature from making IRC approval a prerequisite to appointment to the Ethics Commission. Now, we've discussed quite a bit about Article 5, Section 4, the Appointments Clause. I just want to make one quick point on the non-delegation clause, Article 3, Section 1, in particular, in response to what I heard my friend Mr. Hunt say. I heard Mr. Hunt to focus, and he did in his brief as well, on the public-private distinction, the nature of the membership of the IRC, the law school deans, as private citizens. That is not a matter of concern for the non-delegation clause. The non-delegation clause asks only whether a certain type of power can or cannot be delegated out of the legislature. In terms of once you already get out of the legislature, whether it's delegated to person A, person B, etc., the non-delegation clause, which is the only provision on this issue that plaintiff invoked, is simply inapposite. That may well be a matter for the separation of powers, but that issue is not presented here. Mr. Levine does not present a separation of powers question. And that takes me to my second and what I intend to be my final point, that the Cuomo case that's pending now in the third department, on which I take Mr. Hunt to rely, is inapposite. That case concerns the Ethics Commission's investigatory and enforcement authority, whereas here we're concerned about the appointment procedure. As I just discussed, the lower court in the Cuomo case found the Ethics Commission authority, again, a different type of authority, unconstitutional, based on the separation of powers, which is not the basis for Mr. Levine's challenge here. And as one final testament to the unrelatedness of the Cuomo case, plaintiff, Mr. Levine, in this case, he moved to file an amicus brief in the Cuomo case in the third department, attempting to lodge basically the same brief that he filed with this court. The third department rejected that amicus filing. It did not grant him permission to file. I couldn't think of a stronger testament to the unrelatedness of the two cases. So unless there are any further questions, we would ask this court to affirm the decision below. Thank you very much.
Thank you, counsel. Case 288, Chapman versus Olean Central or General Hospital. Olean General Hospital. My apologies. Okay, counsel are present. Can you both hear me?
I can hear you, Your Honor.
I can hear you, Your Honor. Can you hear I?
We can hear both of you. Very good. Please proceed, counsel.
Yes, thank you, Your Honor. John Collins on behalf of Edward Chapman, the plaintiff in this action, whose position here is that Supreme Court erred in granting the defendant hospital's motion for summary judgment and in denying his cross motion to interpose a second amended complaint adding a medical malpractice cause of action in this case. As the court is aware, basically there are two claims at issue in this suit.
We've got a premise liability claim, and we also, interestingly, it was a question below whether you were even making a claim for medical malpractice based upon the negligent discharge, right? But you're making that, you're arguing that you want that claim now to exist, correct?
Yes, we did, as Your Honor notes, based upon, a string of cases, a lot of them emanating from the Fourth Department, conclude that this was a common law liability issue on the improper discharge claim. And the defendant hospital said, no, this is medical malpractice, it's not common law. And they went on to interpose expert affidavit by a registered nurse who opined that, there was no impropriety in the way that Ms. Chapman's, care and treatment and discharge deviated from, what is a, reasonable standard of care. We, as the court is aware, in the face of that argument, cross-moved for leave to add a medical malpractice cause of action in addition to and in conjunction with our original common law claim on improper discharge.
Counsel, could you answer this if you would, please? Would a fair reading of your original complaint and the bill of particulars allege a negligent discharge under the umbrella of medical malpractice?
Well, it alleged improper discharge, and it, really, that's what it said. So I think that one could, and the hospital certainly did piece it together and say, whatever you say, this is a medical malpractice cause of action. And we're going to
it was commenced within the shortened period of the statute of limitation for medical malpractice cases. There's no issue before us with respect to that, right?
That's right. It was commenced well within the 2.5-year statute that would govern that.
Okay.
Go
ahead.
Yeah. If I may stay in there for just one moment, a certificate of merit was not filed at that time, though, correct?
No, there was no certificate of merit because, as I, concede, our position was that it is, as with many cases involving falls, especially falls of elderly patients, we thought it was a common law negligence claim. And so, but I think that, leave should have been granted to interpose the medical malpractice cause of action because there would be no prejudice, no surprise whatsoever. And that is established by the fact that in moving for summary judgment, the hospital says, however you characterize it, it's medical malpractice, and we're entitled to summary judgment for these reasons based upon this expert affidavit. So they certainly can't claim surprise or prejudice because they treated the case as one sounding in medical malpractice, tried to establish why they were entitled to summary judgment dismissing that claim, and we in response both cross-moved to interpose the claim that they elected to treat as malpractice and interposed an expert affidavit by an emergency room physician explaining why, there were multiple problems here with the way that, the discharge occurred.
We would agree with you on that.
With respect to the certificate of merit, counsel, the remedy for a failure to file a certificate of merit would be a direction from the court to file one as opposed to a dismissal of the claim, wouldn't it?
That's correct. It's not deemed to be jurisdictional. And so in conjunction with the, motion to make, we interposed the proposed second amendment complaint, which contains a certificate of merit, and really everything that would have been in the certificate of merit is set forth in even greater detail in Dr. Stearns's, affidavit in support of our position and in opposition to the hospital's motion. So, there's no prejudice, and all of the procedural steps, to the extent they had not been taken before, can be remedied at this juncture.
We would agree with you and allow you to go forward with a complaint that alleges malpractice, medical malpractice at this point. Do you believe that discovery should be reopened and they'd have an opportunity to pose people to flesh that issue out that admittedly was not in your complaint to begin with?
We did in the trial court when this cross motion was made, as set forth in the record and my brief, offer to let the defendant redepose Mr. Chapman, who became the plaintiff in this action following the death of his mother. And I think that was really the only, claim of prejudice that the defendant was making, is that they didn't have an opportunity when they questioned Mr. Chapman to, ask questions that they would have asked had they known this was a medical malpractice claim.
But
So you're not opposed to further discovery. You're not saying just go to trial on your new claim without any further discovery. Sounds like you're open to that.
Yes, Your Honor. Yes, Your Honor. To the extent it's limited to the new claim, we wouldn't want to,
Right.
hash everything that was done before.
Correct.
And, just to briefly close up on the improper discharge claim and the motion to add a medical malpractice cause of action, I noted that, our physician expert, did establish various reasons in his affidavit as to whether the hospital and its staff properly assessed and documented Ms. Chapman's fall risk, whether they unreasonably and impermissibly failed to ensure that she was taken out to her son's waiting vehicle by wheelchair as opposed to just having her walk out there, and whether they discharged her in, sock feet in the middle of December, knowing that she would be walking outside accompanied by her elderly husband, who himself died about 4 months later. So if there's not any other questions on improper discharge and cross motion to amend the complaint issue, I would like to briefly discuss the premises liability case. There's a triable issue of fact as to whether Ms. Chapman slipped on ice that is raised by her excited utterance, spontaneous declaration.
And that's really, counsel, that's really what you're asking us to decide, whether or not in the context of how this all unfolded, was it an excited utterance? And therein will lie whether or not it can be used and admitted in evidence. Is that right?
Yes, and I think it is clearly an excited utterance. Ms. Chapman had fallen, broken her hip. The medical records established she was unable to move her leg.
When does the record tell us when she said that, when she uttered those words?
I think when you look at the record at pages 141 to 142, it's not, absolutely certain, but I think it certainly indicates that she made that statement soon after falling, right after her son got out of his waiting vehicle.
How do you know that? How do you know it was soon after falling and when she got out of the vehicle, or the son got out of the vehicle?
Well, he said that, when asked about the timeline and did he notice ice, he said he was really concerned about whether his, just getting his mother off the ground. And, the record establishes that soon after falling, she was taken by EMTs, put on a gurney, and taken back in the hospital. So I think all of this, I think it's reasonable to infer occurred in that time between, the fall.
Couldn't have that counsel been corrected with an affidavit clarifying his testimony?
It possibly could have, Your Honor, but I don't think the absence of an affidavit, negates the fact that, on the record as it stands, there's certainly an indication that she made it, while on the ground, while he was concerned about getting her off the ground, and within several minutes after, this whole incident had occurred, not, sometime later. And I don't think there's any indication that given her age or condition, she had time to, deliberate and come up with this, plan to, establish a basis for a lawsuit. She was just trying to explain, how she happened to fall and said she slipped because it's icy.
We'll take a look at that, counsel. Anything further?
And also on the issue of the premises liability, the fact that the son said, I didn't see any ice, I think is not dispositive given his mother's, contrary statement and his concern about her welfare, not the condition of the parking lot. And the hospital, I submit, failed to establish lack of constructive notice because all they did was put in proof as to their general inspection practice, and failed to establish lack of actual notice because the facilities director interposed an affidavit where he said, we have security personnel out in the parking lot, but there's no indication, no affidavit, no proof from those security personnel that they didn't see ice. In the absence of that, the hospital failed to establish its prima facie entitlement to summary judgment. With that,
Thank you, counsel. Mr. Bachman?
Good afternoon, Your Honors. May it please the court. My name is Mark Bachman on behalf of the respondent, Olean General Hospital. I'll try to keep this short, and of course, we'll answer any questions that the court may have of me. Starting with the negligent discharge claim, I think a review of the history of the course of litigation is important here. And for over 2 years, we went back and forth with plaintiff's counsel about the nature of this claim. And there's various emails between the parties and the parties in the court that are attached to the record that unequivocally show that the plaintiff, this counsel here has said on numerous occasions that this is not a medical malpractice case. This is a premise liability.
Counsel, let me ask you this. You know, and we're familiar with the record with respect to those aspects. Plaintiff's counsel clearly was saying that this was not a medical malpractice case. But you know, there's some validity to the argument that these are really fact-specific cases as to whether or not they fall under the column of just general negligence, or they fall under a medical malpractice, in this case, alleged negligent discharge. And when it's a question like that, which it seems from the record that you know your client was concerned about, was asking questions about, wanted confirmation about, and actually responded with an affidavit concerning there being no medical malpractice based upon discharge. All of this was discussed and litigated, and people were on notice. Why would it be wrong to allow an amended complaint at this stage?
It's a good question, Your Honor. It's because we have a situation where they're saying that there's no medical judgment involved in this case, right? So now it goes down to the physical, the manner, the mode of the actual discharge, and the person that's doing that is the registered nurse, and she was deposed in this case. So in order for us to properly defend whether the physical or the manner or the mode of the discharge was proper, we need someone with that experience, with that understanding, that day to day, okay, I have discharged a patient in this situation out of the ED before. We're not going to get someone across the street to say whether this was appropriate or not, or whether this was negligent. And that's exactly what we did in her motion, or excuse me, in her affidavit. She talks about, okay, if this is, to the extent this is a medical malpractice claim, it fails. And then later on, her affidavit says, even if the court finds that this is not a medical malpractice claim and it's just simple or ordinary negligent, it still fails. And yeah, she had to go through some of the care and treatment, but the difference between her affidavit talking about the care and treatment and the plaintiff's physician affidavit is there's a completely different level of intricacy. She's talking about, okay, hey, Nurse Hurlbert was seeing the plaintiff for 6 hours in the emergency department, doing her rounds, checking her vitals, making sure everything was okay. And now you have a plaintiff affidavit from a physician saying, whoa, you got to look at her vitamin D. You got to look at all these little things. It's a higher level. Had we known that this was going to come into the medical judgment aspect, we would have not only retained the services of an emergency expert, medicine expert, and we would not only just redone the plaintiff's deposition, but we would have done maybe the PA that looked at Mrs. Chapman, maybe done the doctor that was in charge of supervising the PA. There's a whole litany of different discovery that could have came out had given the opportunity before we, brought a motion, before a note of issue was filed, before trial dates were ever on the calendar. They just decide in response, because we talk about these things, okay, now we have our opportunity to bring all these different allegations in.
What prevents you from doing that now?
Well, now we have to go back, and you're delaying and you're expanding discovery when for 2 years straight you had the opportunity to do this, and you got to see our cards, you got to see our strategy. We brought a motion, and now you're seeing this motion and you're saying, okay, we're going to bring a physician affidavit in here saying that you had to scrub every single aspect of this woman's care and treatment and make sure she was okay to be discharged. We're at a disadvantage. Now they've seen our arguments. They see what we're going to argue, what we're going to go into that piece.
Yeah, I don't think the claim is that she shouldn't have been discharged. It is that she shouldn't have been discharged with socks on and without a wheelchair and without without precautions taken. I think that's the general claim, but we understand your point.
Sure, and if I may just add, Nurse Reed goes into that stuff and she talks about the policy and she talks about how all these things, regardless of medical malpractice, it wasn't negligent to allow her to go out in the socks. There's nothing in the policy about you shouldn't discharge a patient in socks, and there's nothing in the policy about you should discharge a patient in a wheelchair.
All right, we'll take a look. Anything further?
Yeah, and I would just add for the premise liability aspect of it, this is pretty clear cut and dry. You have a situation where causation is totally based on speculation. The evidence in the record is overwhelming.
Causation is based upon the alleged statement of the victim who fell and was injured, who said something about icy conditions or slipped on ice or something like that. And I'm not sure that the record is as clear, at least I'll have to go back and look at it, as clear as Mr. Collins seems to think as to when that was said. And so that concerns me. And if it's not an excited utterance, it doesn't come in, then where's the evidence of the icy conditions?
That's exactly it. So she said that she slipped, or he said his words in the deposition was, I guess she slipped. And then he later on went down the line to say, yeah, she said she slipped because it was icy. But immediately following that portion of his testimony, Mr. Chapman is asked, well, did you see anything on the ground in that area? And when he's pressed, he says no. And he said multiple times throughout his deposition, hey, I didn't see anything unsafe, slippery, icy, or dangerous in the parking lot.
He also said something effective, because I was concerned about my mother. I wasn't focusing on the condition of the ground in terms of, whether it was icy or not icy. I can understand that, that response. I'm just concerned. I just don't know whether or not the mother's response is close in time to when it happened.
Well, that's a good point, Your Honor. If you read the testimony, he says when he gets out of the car to go see his mother on the ground, because he did not witness it at all. He didn't witness his mother fall. He didn't see her feet. So he gets out of the car and he goes to see, and he finds his mother on the ground. And in fact, he says that she was in so much pain that she wasn't talking. He says it twice. And then she's talking to the EMT that they called over to help. He says he can't really overhear him, but he point blank says twice, she's not talking. She wasn't talking at that point. She was in pain. In fact, he offers, hey, she wasn't in the talking mood at all to say anything. So it's like, when did she say this? When did she say, hey, I slipped on ice? Was it when she eventually was brought back in the ED and had time to reflect, to think about what happened there? And then later in his testimony, as you'll see, when she's actually admitted to the hospital, they actually discussed, hey, why did this thing happen to me? They were trying to go over what happened. Why did this happen? And those are his words. So it's clear that they don't know what happened. And maybe she had a belief that she slipped, but he's right in that immediate area looking around. He may be concerned with his mother. But if your 87-year-old mother slips and falls and she's in a lot of pain and you're in that immediate area, there's a good chance you're going to see whether there's something on the ground there that could have caused it.
We'll take a look at that, counsel. Anything further?
That'll be it, Your Honor.
Thank you.
Thank you.
Case 290, McGill versus Campbell. Okay, we have all three. I'll presume that everybody can hear me. Now, Mr. Sendiak, can you speak up so we know that we can hear you?
Yes, can you hear me, Judge?
Very good. Ms. Long?
Can you hear me?
Very, very good. Yes, Mr. Carey?
Yes, Judge, can you hear me?
Terrific. Very good. Thank you. Counsel, please proceed.
May it please the court. It is my position that the lower court erred because it did not follow the required analysis as set forth in the Goodwin and Gomez cases. The plaintiff's attorney, though, did conduct the required analysis and came to the conclusion that there was no good faith basis to oppose the defendant's motion. The lower court made two mistakes. The first of which, in its opinion, it wrote that my client was traveling fast, but the court did not include in its decision the rest of the quote from the plaintiff. The plaintiff was asked if she was able to provide a speed of the defendant's vehicle, and she said she could not. Likewise, the left-turning defendant, her testimony was the defendant was traveling between fast and slow, whatever that meant. The bottom line is that the defendant established that he had the right of way, that he was traveling at 30 miles an hour, 15 miles per hour, below the speed limit. The second mistake the court made was that although it admitted and conceded that my client had very little time to avoid the accident, the court found that my client was not entitled to summary judgment because he took no evasive action. First of all, I don't think a defendant under the Gomez case is required to establish that he took evasive action. But in any event, the defendant testified that he applied his brakes, and the left-turning defendant testified that she saw my client swerve in an attempt to avoid the accident. So what the lower court did not address is the argument by my opponent, Ms. Long, which in sum and substance is that my client failed to see what was there to be seen. And I'll say this on that argument. I would like the court to focus on the testimony of Ms. Long's client, who was standing in the center turn lane waiting to turn left. Her testimony is clear that at one point she saw my client approaching, and then she lost sight of my client because her vision of my client was physically blocked by a line of vehicles in the left northbound lane on Transit Road. I asked the court this.
Mr. Sunjak, just as a point of clarification, she's in a Dodge sedan in the middle lane. He's in an SUV. He's higher than she is, and he kind of scoots around this other line of cars, right? Or am I wrong about the nature of the vehicles?
Judge, there are photos in the record on appeal of my client's vehicle. He's not driving a pickup truck or a Chevy Tahoe or a Suburban. He is what I would, if you ask me, he's driving a compact or a mid-size SUV. He's no higher than most other people driving those vehicles. The testimony, Judge, is my client is at a red light at Millersport and Transit. The light turns green, he makes a left, he enters the left northbound lane, sees a line of vehicles stopped in front of him. His testimony is he put his right turn signal on, he checked his rear view and side view mirrors, and then went into the right lane where he was proceeding to accelerate to get to the 45-mile-an-hour speed limit. It is undisputed that the defendant testified that he was traveling at 30 miles an hour and he had 1 second to avoid the left-turning vehicle. In fact, the left-turning vehicle driver said the first time she saw my client was when he was 1 foot away. But going back to the vision issue, I would ask the court to focus on this. If the left-turning defendant can't see my client's vehicle approaching because her vision is blocked, there's no way my client could see the left-turning defendant through the same line of traffic. In sum and substance and in conclusion, the lower court erred, and I ask that the order on appeal be reversed in its entirety. Thank you.
Thank you, counsel. Counsel?
Thank you. May it please the court, Nancy Long for respondents Sarah and Darren Campbell. It was established on motion that my client, Ms. Campbell, was negligent and a proximate cause of the accident. That issue is not disputed on this appeal, but as this court is well aware, there can be more than one proximate cause of an accident. And it's our position that on motion, Mr. Sandell failed to meet his initial burden of establishing that as a matter of law, he was not negligent in the happening of the accident. The evidence established that he was in the left lane when he turned onto transit from Millersport. Traffic in that lane was stopped. He saw that the right lane was clear, and he moved to that lane to avoid those stopped cars. Once in that lane, he accelerated his vehicle and paid attention only to that lane of travel. He stated several times in his deposition, "My focus was straight ahead." And referring to the left lane, it was not my focus. He paid no further attention to what was going on in that left lane, despite not knowing why those cars were stopped. He assumed wrongly that they were stopped for a light further up ahead. He cared only that.
Ms. Long, is your argument that under the circumstances then present, it would have been prudent for him as he approached that intersection to slow down so he could see what could be seen to the left of him as he proceeded through the intersection?
Yes. So he
You're
acknowledged
saying that ought to be a jury question.
Absolutely. He acknowledged knowing that Niagara Produce in that area, he was familiar with it. He was on his way to his parents' home. He had taken that route before. He knew that it was busy, especially on Sundays. He also was aware that vehicles do stop to let vehicles turn left. So, I don't dispute the court below correctly found that my client was negligent for making that turn. But again, there can be another proximate cause of the accident. His focus at that point, admittedly, like I said, was solely on his lane. But as a driver, we've got a duty to pay attention to what's around us and to see what's there to be seen. He doesn't.
Do you agree there's no evidence that he was speeding or driving in excess of the limit?
With regard to driving in excess of the limit, I would point out that in order to be negligent, we don't have to establish he was driving in excess of the limit. He needs to be driving, for the conditions. Our argument is that under those circumstances, he was driving too fast at that moment for the conditions, accelerating into an area where he was not paying attention to what was going on in that left lane, despite knowing that traffic was backed up in that left lane. So
was he in a position, would he have been in a position to see from where he was coming in the right lane with the cars on the left lane stopped ahead of him? He wouldn't be able to see Campbell's vehicle until it's almost too late, right? So he almost has to come to a stop. You're saying, I'm not saying you're wrong, but I'm just trying to consider, what are we asking this man to do while he's driving? Does he have to really slow down and come to a crawl there to see if someone might be turning left in front of him?
I don't think he has to come to a crawl, but you have to look. The proof is he didn't look at that left lane. He was adamant my focus was on the right lane. Had he looked, there's a question, would he have had time?
Counsel, what do we do with the idea that he has a right to presume that the other drivers on the road are going to act in accordance with the rules of the road, and that is not make a left turn in front of him until it's safe to do so?
Okay. So, yep. So even though he has the right of way, he does have that right, but he has to keep a proper lookout. By his own admission, he didn't keep a proper lookout. So as drivers, we do have the right to assume other drivers are going to follow the rules of the road and, pay attention, but they don't always do that. And as a driver, we're not absolved of our own responsibility simply because we relied on them to do the right thing. You still have to keep that proper lookout. He failed to do that here.
We'll take a look at that. Anything further?
Just briefly, with respect to the Gomez case, I think this case is distinguishable. In that case, this court specifically pointed out that there was no evidence of a lane change leading up to the accident. Here, we've got that lane change. I think that's what changes things, is that immediately before he's moving into this right lane because he wants to get past these stop cars, but gives no consideration to what's going on in that left lane. And, I know Mr. Senziak pointed out that, well, plaintiff didn't dispute that. And I don't think that's, an issue for this court to rely on. Well, plaintiff didn't oppose the motion. I think this court needs to look at the facts of the case and whether the co-defendant Sandell should still be in this case. And it's our position that he should, and that a jury should decide whether his actions were a proximate cause of this accident as well. Thank you.
Counsel. Counsel?
Thank you, Your Honor. For our position, it's correct that we have focused our motion on the negligence of the Campbell defendants. And I think counsel for the Campbells have correctly stood on the one issue that they may have. We did not oppose the plaintiff or defendant Sandel's motion because I felt constrained by the Fourth Department's decisions in Gomez, Godwin, Penda versus Duval, and frankly, some other ones that I don't know that have been cited, but Christine LH versus Gravovac and Carpentieri versus Clock, which all seem to indicate that on the facts of our case, this was a clear issue of the Campbell's defendant's negligence, and did
Which
not.
Council's pointed out has been established. The only issue really before us relative to that is
correct
whether or not there's, the other defendant has some percentage of responsibility.
And I would agree with defense counsel for Campbell's that she's focused on the singular issue there is whether or not the defendant Sandel, it's clear he could have looked to his left. The question is should he have, and it also clear it seems that he did not. So our position is if there's a question of fact, and honestly, Judge, procedurally, what I did not want to have happen is us have a question of fact, go to trial, have a verdict, spend a lot of money, and then have it all come back and have it reversed against defendant Sandel on the grounds of the holdings of the Fourth Department in those cases that I cited. So
we'll take a look at that, Counsel.
All right. Thank you, Ron.
Thank you, Counsel.
Thank you.
Case 292, Follett versus Drummond.
Good morning, Your Honors.
Good morning, Counsel. Can you hear us?
I can hear you.
Very good. We can hear you too.
Judge, it's just taking a moment for the other counsel.
Thank you. Appreciate that, Michael. Mr. Longstreet, welcome. Can you hear us? We need you to unmute so we know we can hear you.
There we go.
Very good. Terrific. Okay, let's proceed, Counsel.
Thank you. Sorry about that. Michael Longstreet on behalf of the plaintiffs. The lower court issued 3 determinations in this declaratory judgment action. We agree with the third one. We don't agree with the first 2. I'll start with the second one, which has to do with granting exclusive possession to the tract or to the.
Counselor, can I back you up for just one moment here, just preliminarily? There's 39. There are 39 lots in this subdivision.
Yes.
And we have 11 plaintiffs.
Correct.
So are there some lot owners who are not in this lawsuit?
There are, yeah.
And they would have an interest in the park, the private park?
Correct. And the reason we brought it was because the use had changed so dramatically. We needed to get a declaration as to what the defendant's rights were to improve that lot.
Yeah, are they necessary parties?
Well, they're necessary parties if the court has to make a determination as to what's in their deeds. But what we were trying to do was determine that defendant didn't have the right to do what he was doing.
But and just to stay with the preliminary issues here, counsel, for a moment, as I understand it, the initial motion was for a preliminary injunction.
Correct.
And somehow, though, we got the ultimate relief was decided in connection with that motion?
So we met with the judge, counsel and I, and had conferences conference or two about this, and there was a decision on the part of the judge to make a final determination as to the rights of the parties. Defendant did not appeal. We did not object to that part of the determination. So here we are with 3 declarations, and I don't have a problem with the judge making a declaration. Problem I have is the extent of the declaration in favor of the defendant. It's our position that there's no reasonable basis to grant exclusive rights to the defendant over the easterly 50 feet. If you look at the map, the lower court's determination is inconsistent with that, because right over the map are the 50 feet boundary is the word park reserved for tract owners, so or cottage lot owners. So there's just no reasonable basis for that. The second issue has to do with the defendant having the right to build, maintain, and improve on that part of it. Our position is defendant's not the tract owner. The tract owner is the person who put the tract together. Throughout the deeds, there is reference to tract lot owners. It's hard to say exactly what the intention was when all this was granted, but we submit it wasn't that the park lot owner was entitled to the exclusive rights over that. And if he still has the rights to build, maintain, and improve, then those rights are for the benefit of all the other people who won't have an interest in this park. The way this came together was the defendant bought the property, stripped the trees, and went basically 100 feet way over the boundary line with a trailer and a couple of sheds. Now those sheds and the trailer are on the easterly 50 feet, and according to the lower court, we don't have any interest in that, which is completely inconsistent with the rights that we have been deeded.
Would you agree, Mr. Longstreet, that if Mr. DeVer Godfrey, back in the day, DeVer Godfrey, wanted to reserve the right on the 50 feet there, if he wanted to clear that and build something, even though that infringed on the lot owner's access, he would have been allowed to do that consistent with the deeds and so forth?
Yeah, well, I guess would it have been for his exclusive use or not? Yeah, the person who came up with the tract would have been able to build, maintain, and that part of the lot, but
for his own benefit and use, right?
I don't see that in the deed, because if you look in the deeds or in the map, because if you look at the map, reserve park for tract owners is across the 50 feet. It's on the entire 150 feet of this parcel. So it would be inconsistent to come to that conclusion. We do somewhat have a difference of opinion with the lower court about parking on this property. We submit that parking is not consistent with the purpose of this being a park. But having a park with 39 owners, we're going to have disputes and whatnot, and we anticipate down the road in any event. There's mentioned in defendant's papers about we didn't put all the deeds into the record. Again, that wasn't appealed. I thought we had sort of a tacit understanding that the court was going to determine the issue. So unless you have any other questions, that's our position.
No other questions, counsel. Thank you. Counsel?
Your Honors, thank you very much. I appreciate it. And David Temis on behalf of Ronald Dumont, the defendant in this action. May it please the court, we understand the plaintiff's concerns here, and However, the deeds that the deeds that has been provided to the court is just the Follett deed. And it does not contain any transfer of any fee interest. It is merely an easement to use the property primarily for ingress and egress and for recreational purposes. The deed itself is silent as to the location of parcel 4. The only way to identify the parcel would be by reference to the map, and the map clearly reserves to the tract owner at the time the right to develop the easterly 50 feet. And it does it not only within the text on the notation of the map, but also the actual survey itself shows the subdivision of that parcel, including an easterly 50 feet subdivision. The plaintiffs in this action. Oh, please.
Yeah. What about the issue of the necessary parties?
Your Honor, given that the court found in favor of Mr. Dumont on the 50 feet, I think that finding would be binding on all of the other parties. We wouldn't. They've had their chance, and we've now proceeded with the court on that. It was not my decision to bring this on behalf of only 11 plaintiffs. It's not my decision to bring it and only put in front of the court the deeds without a map. But that was Mr. Longstreet's decision. And, given where we stand, we did not anticipate the court at the time we briefed it. We did not anticipate the court entering the final declaration. And so, those issues had not necessarily been fully developed at the lower court. Notwithstanding, I think the court's ruling is sufficient for the rights of Mr. Dumont. The plaintiffs here are claiming all the rights and privileges of land ownership without any fee interest in the land. And Mr. Longstreet's argument that reservation of rights was merely a license personal to the tract owner just runs contrary to the well-established rules of property law in New York. An easement is only what is granted, and the grantor can reserve whatever rights for themselves they want. And when they subsequently transfer that fee interest to the subsequent owner, then with that comes their reservation of rights, including the right to build, maintain, and improve the easterly 50 feet.
Anything further, counsel?
What's that?
Anything further?
No, Your Honor, I think you grasped the issues. I appreciate the court's time.
Thank you.
Thank you.
Case 287, Burns versus CRB Holding. Justice Del Conte is recused from this case. We've lost Justice Ogden. Oh, there we go. Mr. Byrd, very good.
Good afternoon, Your Honors. Can you hear me okay?
We can hear you fine. Mr. Englert?
Good afternoon, Your Honors.
We can hear you fine also. Please proceed, counsel.
Thank you, Your Honor. Matt Byrd on behalf of Jason.
Excuse me, counsel. My apologies for interrupting. I'm asking you to make your argument, and then I jump right on top of you. I just want to make sure that both of you heard that my announcement that Justice Del Conte is recused from this case.
Yes, Your Honor.
Right,
yes, Your Honor, I did hear that.
Thank you.
So Matt Byrd on behalf of Jason Burns, the plaintiff in this matter, we are asking this court to look at and reverse a decision of the lower court which granted the defendant's motion to dismiss. There's an extensive record here. All the points are addressed in the brief. Is there any specific questions you have for me, or would you like me to elaborate on certain points?
Why don't you go into your argument, and we'll ask questions as need be.
Thank you, Your Honor. Essentially, this is a dispute between a father and a son. It's our position that the complaint sets forth in detail the allegations against the father with respect to corporate assets. It's also our position that, and this is addressed in the declaratory judgment cause of action, the first cause of action, that Our client is still a shareholder of this corporation. There has been no
Your
closing.
argument, counsel, your argument is that your client never gave up the shares, right? That there was a communication and a right for the shares to be transferred, and there was I guess, a request, but that was going to be put off for some time, and it was never satisfied within the time period, which was, I think, was it 60 days?
That's correct. Yep. And that's our main position here. All these other cause of action kind of flow from that, but that's the main takeaway from the brief is that he's still a shareholder here.
Right.
And just to elaborate on that, I think the lower court respectfully erred is with this declaratory judgment cause of action. Justice Walker essentially made a determination that he was no longer a shareholder. I think that was improper at this stage of the action. That will, if the case is able to proceed, that'll get flushed out during discovery and eventually at trial. But that's our main point, Your Honor.
Very good. Anything further?
Nothing further. I'll just rest on the brief and thank you for your time.
Very good. Counsel?
Thank you, Your Honor. Charles Englert for the respondents. Just to touch on the point Mr. Byrd raised, the appellant was not a shareholder of the corporation at the time he filed the instant lawsuit. The shares closed in June of 2021, and we believe that the lower court properly determined the closing occurred. The 60-day period was not a material term of the 2014 shareholders agreement, which is the operative document governing the affairs of the corporation at that time. The respondents indicated their desire to repurchase the shares from the appellant within that 60 days. Then the shares were valued in accordance with the corporation was valued in accordance with the shareholders agreement. There was
counsel, the argument that you just made about it not being a material term, the 60 days, and also the location of the closing not being material. Were there any facts that established that between the time of Judge Walker's initial ruling, or his ruling that he made, we have it in the transcript, on the initial motion to dismiss versus the decision at issue here? Did anything change? Was there any new factual allegations or any development of the record on that?
No, Your Honor. But I think the record fleshes out that the parties were engaged in negotiations regarding the sale of the shares. The corporation was valued by pursuant to the shareholder agreement that wasn't enforced at the time, and the shares closed in June in accordance with the material provisions of the contract.
At first, Judge Walker said, I can't decide the standing issue because we have this separate issue that we have to first decide, is he a shareholder or not? He said that. You're claiming that was incorrect when he first said it, not the second ruling where he switched.
Oh, I'm sorry, Your Honor. I misunderstood your initial question. I believe that the first ruling was, it's not that he didn't deny or not that he didn't grant dismissal on that issue, but he allowed plaintiff to replead that cause of action. And upon the motion for dismissal on the amended complaint, the cause of action was more fleshed out that the shares did appropriately close in June of 2021.
How was it more fleshed out? I just have an attorney affidavit. I don't have anything new on the second set of motions.
Well, there was no pleading that the date and time were material provisions of the shareholder agreement.
Well, why did no claim to that the first time around, and then there was a claim the second time around?
Right. In the amended complaint, there was no specifically pled allegations that the time period and the location of the closing were material provisions. That didn't come up until briefing on the motion.
I see. Okay.
We'll take a look at that, counsel. Anything further?
Unless the court has any further questions, we'll rest on our brief, Your Honor.
Thank you, counsel.
Thank you.
Case 293, Weiner versus Liselette Roth Weiner. Okay, Counsel Weber, can you hear us?
I can hear you, Your Honor. Can you hear me?
I can. Counsel, is it trying?
Priyan, yes,
Ian, my apologies. Can you hear us?
I can. Thank you.
Very good. Please proceed, Counsel.
Good afternoon. May it please the court. I am Rick Weber from Bond, Shattuck and King, here for appellant and defendant.
Counsel, I'm
Lisa
going to do what I
Roth.
did. I'm going to do what I did before. The very last case, I've made the same mistake twice. My apologies. I do need to announce that Justice Del Conte is recused from this argument. Now proceed.
Oh, all right. Once again, Rick Weber here from Bond, Shattuck and King, on behalf of defendant Lisa Roth Wiener. I know we've certainly all been here for a long time today. I'll try and keep this brief. I'm going to start with a rhetorical question. This is not a question I expect the court to ask. I understand this is a role where the court asks advocates questions. But if I were to say, how is your present pension doing? I would respectfully submit that most anyone would view that as not only a marker of a description of an item, but a marker in time, namely the present. And that is where we stand on this case. That's the primary section that we believe is where the lower court erred as it moved forward in considering the motion for summary judgment on liability and on damages. This case regards a 44-year-old separation agreement. It was a separation agreement that predated our equitable distribution construct. Under that separation agreement, it made very clear that it's section 1B, the parties were relinquishing any and all of their rights to all claims, including any rights they may hereafter acquire. But then it has an exemption, a carve out for that. And it's a carve out for Ms. Trian's client, Lois Wiener. Now, Lois Wiener is no longer in the case. Lois Wiener assigned her rights to her son, Jeffrey. So for purposes of how the court is viewing this, it's Jeffrey on one side of the aisle. That would be Irwin's surviving son and Irwin's surviving widow, Lisa. Neither of these two are parties to the contract. Neither were involved in writing this contract. This exemption grants to the first wife, that would be Lois, the right to receive upon the death of the husband 33 1/3% of the husband's present pension. Again, we submit that that's a marker of time as well as an identification of an item.
Mr. Weber, I have two questions regarding that.
Yes, yes, Your Honor.
First of all, there was plenty of time from 1980 until the husband's retirement for him to acquire a second or third or fourth pension, depending on his employment and other circumstances. And that would not be a marital asset because it's not his present pension. Isn't that what the judge decided? The judge said that if they wanted to limit it to the value, they would have to insert the words, the value of the present pension. But the present pension just refers to the pension that's in existence at the time, not necessarily the value of it. The value is going to grow, et cetera. As is his salary, as is his income's going to grow, as did his alimony payments grow. So there wasn't any locking into a dollar figure, was there?
Your Honor, I find that response interesting. I think the short answer is yes, there was a locking in. And remember, we're sitting here today in 2024 where any one of us can go look up our respective account balances online. In 1980, that wasn't available to these parties, right? And they used language of the present tense. It's not just of the husband's present pension to the extent that the same might be funded, that the same could be funded, that the same would be funded. It's to the extent the same is funded. They limit it very clearly to derivation from his employment at Upstate Medical Center. That's his current employer at that time. We do believe Judge Karolounis correctly interpreted that there was no entitlement to a pension from a separate later employer. Our position goes further. The entitlement to the pension that Dr. Irwin Wiener had on May 8, 1980 is exactly that. It's, to use a real property analogy, it would be the sticks in a bundle. What was this thing on May 8, 1980?
Mr. Weber,
again,
yes,
Justice Lindley.
Did the party's course of conduct, was it consistent with your interpretation? In other words, it sounds like it was not, that Dr. Wiener was paying not the present day value back in 1980, and then his second wife upon his death or they were paying, the course of conduct was not consistent with your interpretation. Would you agree with that or disagree?
I would disagree with that, Justice Lindley. And the reason I would disagree with that is because I think that falls under a separate portion of the agreement. If you look at the separation agreement, this will be in the record at 46. That section is 2D6, and it talks about what happens to alimony if Erwin Weiner retires. Right? So Erwin Weiner is not earning anymore a traditional income, quote unquote, a salary, wages. But it makes very clear that under that scenario, 1/3 income from any pension would come to, at that point, the first wife, Lois. Certainly, it appears that Erwin made those payments. And towards the end of his life, when he was having difficulty writing the checks, Liesl made those payments. But we're not talking about a continuation of alimony. We're talking about a one-time death benefit that was established and set. The trigger is the death. The benefit was fixed at the time of the separation agreement. That's why they used is funded, right? If they had wanted to say in the future, they could have said to the extent the husband's present pension is then funded or will be funded at such point in the future. They used is. It's a present term. They limited to his then present employer. And they made a point at the witnesseth section of the agreement to identify his present employer. The present employer was an important aspect of this.
But they
you can see that's our the first argument is that certain things run from there. We think present pension, again, to borrow from a real property analogy, it's all the sticks in the bundle. When somebody says present pension, it's not just the word present, it's those two words together. That's the operative phrase. Now, the other thing that strikes me as a bit strange here as well, and I have to admit, I was somewhat surprised to see opposing counsel lean into this so much on our brief. The lower court concluded that this isn't a pension at all. They said, well, this must be an annuity. And the plaintiff respondent has argued this must be an annuity, even though there's language in this agreement that would exclude annuities. Our position is this is a pension. It is the pension as it was fixed at that time period. Judge Karolounis erred in concluding it would expand and add after marriage income and contributions, as well as contributions from another employer. She got that part correct, we assert. But that if it's an annuity, there's nothing to be provided to the plaintiff at all, because of the exclusions under the rest of the agreement. The other thing I think I'd want to mention real quickly here, we had cited the Caravaggio case. Again, we've gone back and forth in the briefs about the Caravaggio case. Some of their arguments about Caravaggio is that Caravaggio couldn't possibly apply because it was overruled by Kaplan. I just want to note, Kaplan did certainly overrule Caravaggio, but it overruled it because of what the Kaplan court described as the revolutionary adoption of equitable distribution of 236B. When this separation agreement was negotiated, when it was signed, we were in the era of 236A. And so some of this may seem inequitable by what our thoughts are today, 44 years later. But frankly, this is one of the reasons why equitable distribution came along. For the purposes of what this court must look at, it must view this under the law that was in effect before equitable distribution. And I would finally note, we decided—
Counsel, you should begin to wrap up, please.
Yes, I'll wrap up. I would commend the court to the record at 752. That's the portion of the record that indicates that annuities are not assignable. This particular thing that was purported to be assigned is not assignable. And then I would also, in conclusion, ask the court about the equities here. What the functional result of Judge Karolounis' decision is to give a windfall to Erwin Weiner's son, a man who was never part of this contract, who was never the intended beneficiary of this contract, and to give that windfall when Jeffrey paid $1 and is now, unfortunately, going to do devastation to my client, a 93-year-old widow. I asked the court to look at the equities and figure out if this really is an equitable result, as the claims brought by the plaintiff are equitable in nature. Thank you, Your Honors.
Thank you, counsel. Counsel?
Good afternoon. May it please the court. I am Stacy Trian of Adams LeClaire, attorney for the appellee and cross appellant. essentially there are two issues here. The first is, how do we interpret the operative clause of the separation agreement? And the second is whether it is enforceable in an equitable claim against the first wife. With respect to the interpretation of the contract, the lower court correctly found that the word present in section 1B1 of the contract referred to the pension as the pension that existed at that time. The only retirement account that Dr. Weiner had that time was the subject annuity account with TIAA, which was it's under statute a SUNY optional retirement program. This was the only retirement account that Dr. Weiner had at the time of the separation agreement.
That was based upon his employment at Upstate, right?
Well, when he first signed up for the plan, he did work at the campus at Upstate Medical. Our position is that his employer at all times was SUNY. He later was transferred to the downstate campus. But it has always been the same pension agreement, the same retirement plan. Nothing changed. In other words, his account went with him. He continued making contributions, and his employer continued to make contributions in the same manner as previously. So the appellant's reading of this clause, as the lower court found, would require the court to insert the word value to the present value of the pension at the time of this agreement. That is in contravention of every other provision in this agreement, which requires payment of a percentage for alimony, for support payments, because the thought was that the decedent, who was a tenured professor and a doctor, was going to have an increase in his pension, in his salary, etc., throughout his lifetime, and that the first wife, who supported the children and was home the whole time while he was pursuing his career, should benefit from that. And that is all in the record. With respect to appellant's assertion that there are exclusions for annuities, there is no provision in this agreement which would exclude the subject annuity contract. That is the only contract that this could be referring to. There was no other pension or retirement plan provided through the decedent's employer. And the court did correctly refer to the course of conduct, as Your Honor mentioned earlier, in that prior to Dr. Weiner's passing, he was making monthly payments of 1/3 of this same account to Lois Weiner, and it would only make sense that that would continue after his passing based on the language in both of the clauses at issue here. With respect to whether this promise in the separation agreement is enforceable in this instance, we agree the separation agreement and the judgment of divorce were entered actually just weeks before domestic relations law 236 was amended to add to create an equitable distribution, which is a different statutory scheme than what existed at the time of this agreement. And that at the time that this agreement was written, Caravaggio did preclude direct actions against a state pension fund for various public policy reasons based on the statutes applicable to those public pension funds. The SUNY optional retirement plan at issue here is not one of those statutory public pension funds was not subject to the same parts of the statute. In fact, under the education law, it's Education Law 390 and 391. This annuity plan was actually a contract owned by the employee, a contract between the employee and the insurer that the employee chose to use. Here it was TIAA CREF. The state pension funds, to the contrary, involved contracts with the state. As I said, had different statutory provisions preventing alienation. And the Caravaggio court even noted that the state constitution in Article 5, Section 7 states that state pension funds are secured by membership in a public retirement system, and these are contracts with the state accorded constitutional protection. There's no such protection to these private plans. Dr. Weiner opted out of that, having a state plan. So
we'll take a look at that, counsel. You should begin to wrap up.
Okay. Briefly, with respect to Jeffrey Weiner's appeal or cross appeal, the lower court incorrectly decided that Mr. Weiner is not entitled to prejudgment interest within his claims for unjust enrichment and money hadn't received. The law is very clear that a party recovering proceeds for breach of an implied contract is entitled to prejudgment interest as of right under CPLR 5001, and that unjust enrichment and money hadn't received are both quasi-contract claims. So the court did not have discretion to refuse to award prejudgment interest here. And another issue that we take with the holding below is the limitation of this award to funds that were deposited into this account while the decedent worked for Upstate Medical. This was the same pension, the same retirement account that was opened in 1965. It followed Dr. Weiner to when he went to from the upstate to the downstate campus. His employer was always SUNY. And so that portion of the decision, we also believe, was decided incorrectly.
We'll take a look at that, counsel. Thank you.
And if there are no further questions, I will conclude.
Very good. Thank you, counsel.
Thank you.
This court
Thank you, Your Honors.
Yes.